Item number 13. May I pray the matter be taken up at 2, Milord?
This court does not take up 2 at 2.
The only problem is, Milord, because Milord, they are behind bar still last 10 years, Milord. So
Behind but 13 years, 12 years also.
understand, Milord, but this is a bail application.
No, this is appeal.
Rejection of a bail, Milord. That is the reason, Milord.
No, if it reaches, we will take up. But we do not take up great matters. This is the consistent convention of this court.
Your Lordship, I beg to make a mention, Your Lordship. First of all, I apologize for making a mention. Item 3 and 4. Your Lordship, I am prepared for the matter. I want to do the hearing. But Your Lordship, difficulty is that there is another matter of 2004, top of the list, item 1. Now, if it is called, can it be at 2 o'clock, Your Lordship? If I am free or
Okay, will not call for the time being. As soon as you are free.
Yes, I apologize for that. I oblige.
I beg to mention item number 8 and 9 on behalf of Mr. A.K. Hussain, my lord. He is out of station, my lord. He instructed me to take adjournment.
You are Mr.
K. Kolita, my lord.
Who is for the appellant?
I am for the item number 9. My friend is from item number 8.
Yes, my lord. I'm for
Item number 9. You are for appellant.
My lord.
Also
Okay.
for the day.
Okay. And who is the appellant in item? You are also in 8, perhaps? Mr.
My lord, not
Sonia?
8, but subsequently my Mr. Mahajan appears in the item
Okay.
number 9.
Yes, Mr. Bora.
Yes, ma'am.
Okay. Mr. D. Bora, learned counsel for the appellants in item 8. And Mr. M. Soronia, learned counsel for the appellants in item 9 are present. MS B. Bhuya, learned senior counsel and additional public prosecutor for the respondent state is also in attendance. Full stop. Mr. K. Kolita, learned counsel appearing for Mr. A.K. Hussain. Learned counsel. This is appeal against conviction.
My lord.
Okay.
But his
For the
appeal-
respondent number 2 has sought an adjournment for the day. Full stop. As the prayer is not objected to by the learned counsel for the other sides, the prayer is allowed. The adjournment.
Maybe
the
day after
appeals-
tomorrow, my lord.
Appeals are
Possible.
adjourned for the day.
My lord, can you
Obligation.
fix the date, my lord?
No, we don't fix that. For the day only. Only day.
My lord.
Obligation.
May I please, Your Lordship? Lordship, I beg to mention for listing of a criminal appeal for hearing column on Friday, my lord.
Hearing column, make an application.
Much obliged.
Lordship, I beg to mention for listing the criminal appeal for order, Lordship,
Order.
order.
Okay, order.
Daily list for admission item number 1.
May it please your lordship. This appeal has been preferred against the my lord impugn order. Postal final case 119, my lord. But issue herein, my lord, only 2 issues. Whether Rule 13, if the Rule 13 is of the Assam Conduct Rules is not followed, whether the degree will be honored by the authority or not. That is one issue, my lord. The other issue is whether the private respondent herein, the writ petitioner, he will get the seniority from the date of his joining, even if he is appointed on ad hoc basis. These are 2 issues, my lord. He has pursued both MA and BEd degree simultaneously from 2 different universities at the same time without obtaining leave from the authority. That is in violation of Rule 13. And that is why, my lord, he was not appointed as in charge head principal of the school. He
Facts are reflected in the order. Let us have the order.
This is the first time, my lord.
This is the first time it has.
Yes, my lord.
And we will issue notice only.
My lord, what happened, my lord, I am.
Somebody hired.
Some bench heard it.
Yes.
One bench initially, my lord, on one issue was raised by the honorable court, my lord, whether I can take plea of the seniority
No, somebody has heard it or what?
Only once, my lord, it was reached before on the court number 2. Court number 2, my lord.
Not one of us.
The matter has been listed on several occasions, my lord, but due to, my lord, some inconvenience of the courts, my lord, it could not be taken up.
Yes, Mr. Roy, we can issue notice, we'll hear for disposal.
But no stay, my lord.
My lord, I am working as principal till today, my lord. Lordship may grant
No, no.
protection.
That
Because, my
cannot-
lord,
Let us
He's-
have that order then regarding interim period and we have to hear.
my lord, Lordship will kindly appreciate page 40. Page 40 is the appointment of the private respondent, my lord, the writ petitioner.
My lord, he has not taken the plea before the. writ
Whether
court, my
pleaded
lord.
case.
It
No.
was, facts was there before the learned, my lord, single judge, but it was not pleaded.
No, no, neither the
But-
fact.
Pleaded.
Not
No,
pleaded.
Ground is not pleaded, then
No,
we'll
no.
have to examine
That
that.
is the case, my lord.
Taken up, my lord.
We
Before
have to
the,
examine that. If ground is not pleaded
yes,
in the writ petition,
yes, my lord.
then we have to examine that issue, whether that can be taken up in a
Yes.
intra-court appeal.
Yes,
And the
my lord,
gradation
on
list
the
is not
count,
on
my lord,
challenge, my lord.
on the count, my lord, I am also relying on a decision of division bench of this honorable court, my lord, wherein, my lord, this honorable court held that additional ground can be taken up in the appeal.
Okay, let us read the order then.
My lord. Order is long order, my lord. Only the,
Where is it? 33/2023 order? In order.
impugn order. My lord.
Let us have a look at the impugn order.
That was my
Page
appointment.
120.
No. The impugn order in the writ petition.
Yes, page 120.
Impugn order in the writ petition.
Yes, page 120, my lord.
No, that is
No,
a
no.
judgment of the
Judgment of
single
the-
judge. Impugn order in the writ petition.
That note.
My lord, Lordship will find that order, my lord, at page 66, my lord,
66.
my lord.
Lawrence Chandra Deka was the writ petitioner.
I was a private respondent in the writ petition, my lord. I
No.
was,
Lawrence, who is Lawrence Chandra?
Lawrence Chandra Deka is the appellant, my lord.
He was also the writ petitioner.
No. My appointment, this
He
order was,
responsible
yes, my
in
lord,
the writ-
yes, my lord.
That's why number,
Respondent number 5. 4, my lord, 4, I'm sorry. Respondent number 4 in the writ petition.
interest of Lawrence Chandra Deka, MA, BEd graduate teacher of so and so. I used to be thereby allowed to hold the charge of principal of the same school to allow it financial power. Provide disburse the salary of the staff of the so and so. By that order, the writ appellant was allowed to hold the charge.
My lord,
Okay, that order was challenged
challenged,
in the writ petition.
writ petition.
Is respondent number 5, not 4.
5, my lord.
From secondary education service उसका नाम नहीं है ना?
সার্ভিস ম্যানুয়াল তো হয়, এখন এডুকেশন ম্যানুয়াল থেকে। Page number, relevant rule is page number 32. Rule 12, my lord. There is no Hobita. इसका कॉपी नहीं है।
What is the difference between provincialized higher secondary school and provincialized senior secondary school?
There schools, my lord, perhaps my lord, the madrasa schools.
School one and two.
Earlier, my lord, earlier there was a difference which has been also explained in the new Provincialization Act. They are alternatively used for to say higher secondary schools should mean, my lord, where there are also lower classes present, but senior secondary schools, my lord, only the two classes were there.
Okay.
They were earlier they were
So in a senior secondary school, there are no graduate teachers.
in a senior secondary school.
All
They
are
would be.
postgraduate
Huh?
professors.
No,
Post-
please read rule 1 and 2, sub rule 1 and 2.
Hmm.
I have seen it for the first time. I have never.
Lordship is referring to page.
Page 32.
32, no?
32.
Higher secondary school, senior
The
secondary school.
post of principal in provincialized higher secondary schools.
Madam, this has also undergone some amendment where now we have included secondary schools and multipurpose
No,
schools.
no,
in
please
numbers.
explain, just let us read together just for our knowledge.
Madam,
The post of the principal in provincialized higher secondary schools shall be filled up by direct recruitment from the candidates amongst the cadre of postgraduate teachers of senior secondary and higher secondary school and graduate teachers of higher secondary school as per procedure of sub-rule 5. Okay. Now 2. The post of principal in provincialized senior secondary schools
filled up
shall
with-
be filled up by direct recruitment from the candidates amongst the cadre of postgraduate teachers of senior secondary and higher secondary. There is another concept, senior secondary and higher secondary schools, as per procedure of sub-rule 2. Here, sub-rule 2, graduate teachers are missing. Right? Just to
Yes.
remove the confusion. Explanation. The senior secondary and higher secondary schools shall include any senior secondary and higher secondary school in the state. I am bit confused.
Now, Lord Supreme kindly have 3 minimum qualifications for appointment to the
No,
post
that
of
is
principal.
qualification.
No, no, that is what I was
What
coming
is
to.
this?
This graduate.
Senior secondary school and
graduate
higher
teacher-
secondary school.
Graduate teachers of high schools have been included in
No, no.
3, 4.
Graduate teachers
Three-
of higher secondary schools.
No, what Lordship
Sub-rule
has-
1.
What Lordship had said was missing in sub-rule 2. Graduate teachers of high schools were missing. That was challenged. And that was introduced in sub-rule 4 of Roman 4 of sub-rule 3. That was inserted by this honorable court saying that it will also contain graduate teachers of high schools and teachers of multipurpose schools. Similar teachers of multipurpose. That was inserted. It is not there in the book. So graduate teachers of higher secondary schools would also be included when they vie for the post. If they have 17 years of experience, they would also be included in that contest. That has been that is not reflected in this book, but that amendment has been brought in by orders of the honorable court. And senior secondary schools would only have
2 classes.
2 classes, and higher secondary schools would have 5 classes.
Okay, okay. A B.Ed degree. Yes, it is not even argued regarding his ad hoc service. Not even argued.
Malad, as regards to Malad, Rule 13.
Whether it is a ground in this writ appeal that I have argued and point was
No,
not
no,
considered.
Not argued for it, not argued. Honestly speaking, Malad, it was not argued. Malad, on the point of Rule 13, Malad, pursuant to an order passed by the Honorable Court, government took this decision, Malad, conscious decision at page 89. Thus will find they have not invalidated the degree, my lord. They have decided not to honor those degree which are, my lord, in violation of Rule 13. In respect of another school, my lord.
They cannot invalidate the degree. There is no question about it.
That is what, my lord,
That cannot be raised also.
yes,
Yes, how to treat the conduct of the person who has obtained a degree.
my lord.
That is given by universities.
My lord, but the
Any
government,
sort of secondary education or higher education cannot invalidate that degree. How to treat it? That is a different issue.
yes, they have decided not to, my lord, honor those degrees which are in violation of Rule 13.
That will be after hearing.
My lord, this is the decision, my lord, will
That
file
will
at
be after hearing.
page 89, my lord. And my lord, as the petitioner, as the appellant is still working, my lord, as in such principal of the school, Lordship may at least, my lord, grant the
We are
status
not
quo.
impressed for the time being.
But at least status quo maybe maintain, my lord. Lordship dispose of the matter next week, my lord. All parties are before your lordship. And even today also, lordship may dispose of, my lord.
Yes, then can dispose of.
Yes, ma'am.
No issue.
Yeah.
Sir, ready?
My lord. Lordship may kindly peruse page 41, my lord. Page 40, my lord, I'm sorry. Page 40 is the initial appointment of the writ petitioner.
Which point you are arguing?
Yes, at this point also I am arguing, my lord.
Ad hoc.
Ad hoc.
Then we have to see your writ petition. Is it a part of your writ petition?
My lord,
Pleading.
this is a part of the writ petition, my lord.
No, your writ petition is part of this writ appeal.
Yes.
Writ appeal.
This was annexed by himself, my lord.
Let
Writ
us,
petitioner
no,
himself.
the writ appeal, sorry. Copy of the writ petition.
Writ petition is a part of the record, my lord. Writ petition.
Let us see. Your,
Writ
the writ
petition
petition.
is starts from page 17 to page 69. my lord.
Your affidavit in opposition. I'm sorry. Your affidavit in opposition.
From page 70 to 76, my lord. This point was not raised, my lord. This point was not raised in the affidavit in opposition.
If it is not, one thing is there that it is pleaded, not argued,
Yes,
right? That is one case.
yes, my lord.
Pleaded and argued,
Right.
but not considered. That is another case.
Yes, my lord.
Now, the third category, not pleaded and not argued.
Yes, my
Your case falls
lord. Under
so
the
far
third
as
category.
ad hoc services concerned,
Under
in
the
the
third
third
category.
category,
Yes, my lord.
right?
Yes, my lord.
So, whether this can be taken up in writ appeal, intra-court appeal.
Yes, my lord. On the
Show me that point.
My lord.
Then you argue.
Page 91, he filed a representation also. There also he has not taken that point.
Intercept, no? Intercept.
It is not considered, then it is a case of review. Pleaded, argued, not considered, it is a case of review.
My lord. Yes, my lord.
Pleaded but not argued, that is third. And pleaded, not argued. That is second, this is third.
Yes, my lord. Paragraph 20 of the first judgment, my lord, division bench judgment of the Honorable Court, my lord.
Copy. Copy के नियम में।
Where it is available on record that ad hoc,
Yes, it is available, my lord. In the writ petition itself, my lord, he annexed. Page 40. Page 40 is the first appointment, my lord, for the period of 3 months. Next, my lord, page 42 is the first extension. Page 43 is second extension. And page 44 is third extension, my lord. And then extension, also you'll find page 46. This is extended until further order.
so far deputation to BEd is concerned, the
That is
petitioner
okay, my lord.
was deputed.
He was deported for BA, not for MA. He has undergone the MA at the same time, my lord, from a different university. From
Is there any
Bodola,
bar?
my lord, under Rule 13, my lord, he cannot.
No. Is there any other bar for any university to simultaneously pursue a degree by distance learning or correspondence? I think the ideal is distance learning instead of distance and open learning.
Yes,
So classes are held on holidays.
yes, my lord.
And is there any bar in law other than misconduct? Is there any bar or prohibition in law to pursue simultaneous degree from two different institutions?
That is perhaps not.
Not.
That is perhaps not.
And that is
But
not
Malad-
full-time. One is
but-
not full-time.
Under Rule 13, there is a bar.
That will come. But so far as law is concerned, there is no bar.
Yes, my lord.
Suppose Mr. Uh, 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 Mr. Iqbal pursues distance learning from IDLE MA course and another course from another
In
institution.
fact, my lord, I pursued.
Are you prohibited?
In fact, my lord, I pursued both MA and LLB at the same time, my lord.
So, if one is not, both are not full-time, one is part-time,
Hello.
I think there is no bar
Yes,
as such. So, if he is not an employee, it would not have been a bar.
yes, my lord.
Now, if he is a teacher, whether it is a misconduct or not. That is issue.
Rule 13
So far,
doesn't say.
deputation is concerned for BEd, it is perfectly all right.
Yes, that is okay.
The Directorate of Secondary Education have permitted him.
Permitted him. For the
And
BA,
so
he has
far,
been.
IDLE is
deputed.
concerned, he was released for pursuing BEd. And where from he has pursued this
BA from Guwahati University, my lord.
Guwahati University, where is the certificate? That is page 56A. Institute of Distance and Open Learning.
Yes, my lord. And MA loss will find this is he said that the earlier principal, my lord, give him no NOC for pursuing the MA degree also. But he was not the appointing authority. Rule 13 says he has to take the NOC from the appointing authority.
Hmm. Let us see your affidavit in opposition.
It starts from my lord, page 70, my lord. Affidavit in opposition is confined to only Rule 13, my lord.
Mhm.
Affidavit in opposition was confined to only in respect of Rule 13.
Rule 12.
But Rule 13 of the conduct rules,
13.
my lord.
So there is no whisper about that.
About the ad hoc appointment, there is no whisper.
Even to raise a point of law, necessary foundation is to be laid. That is also the law of the Supreme Court.
My lord.
Division bench observation I have taken note of, but there is judgment that Bharat something that to raise a point of law also necessary foundational pleadings are to be laid to argue a point.
But the matter is so dear before the single judge.
So far, ad hoc
was
is concerned that there is no whisper.
Affidavit, there is no whisper, my lord.
And this is to be tested so far the other part,
My lord.
whether this authority can prevent him without giving an opportunity to allege misconduct. That is to be examined.
Yes,
This will be a misconduct.
yes.
Rule 13, suppose.
My lord,
Even in
rule-
your case,
Rule 13 says, if
Assam Civil Service Conduct Rules,
conduct rules, my lord. Rule 13.
1965.
No government servant, while in government service, shall join or attend any educational institution for the purpose of preparing himself for or shall appear at an examination of a recognized board or university without obtaining previous permission from the appointing authority.
So
a
misconduct
clear
is to
bar.
be alleged and proved.
It is his admitted case, he never obtained prior approval from the appointing authority.
But that cannot be taken as established.
But that is why, my lord, government has, my lord,
Government file pleading.
government file pleading also. They have, my lord, under rule
Page
25,
77.
under rule 25, they have interpreted. Rule
Let us see your order which you said about similar case, page.
My lord. My lord, page 89, my lord. Which is the decision of the government, my lord, in respect of persons ruled of Rule 13.
Otherwise, there is an opportunity for you to prefer a representation in terms of the judgment. There is an opportunity, page 30. It is further provided that even for a temporary arrangement, the authority is directed to consider all the eligible candidates, including the petitioner, respond number 5, by following the procedure prescribed in Service Rules 2018. Paragraph 30, second line. If you find that he is ineligible on the count of ad hoc service, you can raise that issue. But so far as this writ appeal is concerned, this is the primacy view.
Then, my lord,
In
lordship,
spite of the division bench judgment, there is Bharat and there are many others.
my lord,
That for raising a point of law also, necessary foundational facts are to be pleaded. Because this is not granting an opportunity. So far, this misconduct issue is concerned, we can examine, but at this stage, I don't think.
what I'm, my lord, praying, as the petitioner is, my lord, appellant is working since 2023, my lord, as in charge principal of the school. Till the decision is made by the government, let him work as the principal in charge, my lord.
That has been set aside, is it not?
Yes, my lord. The status quo at least, my lord, can be maintained, my lord. Till the government decides that issue, my lord, in respect of the ad hoc appointment. My lord. Government may decide the matter, my lord, within a very short time, my lord, after hearing both the parties. I was surprised to see the affidavit, my lord. I was surprised to see the affidavit in opposition, my lord. It was not a single word.
Yes, we can issue short notice, we can hear the repeat itself. Yes, Mr. Mozumdar, in the next week, if everybody is appearing, we can issue notice returning within next Tuesday. We can hear it out.
The difficulty the department is facing is, this honorable court said, the difficulty of the department is when this honorable court said that we should have to follow the entire procedure for promotion even for stopgap arrangements. So that will require consideration of all the persons in all these schools, because it's a recruitment process, it becomes a recruitment process for the post of principal. Now, if you have to take the seniority and the qualifications of all the eligible persons of all the schools in that, it will become
Oh,
a very
that-
tedious affair for even for a time gap arrangement. So that part perhaps, my lord, otherwise it will be, it will not be conducive for the schools. The inspector has to be in charge of all the schools till we can make a proper selection for each of the school for a stopgap arrangement. That part, my lord, is only the difficulty of the department, as has been told to me.
Normally, what happens that the qualification required to be fulfilled should be the candidates who will be considered should have the qualification to be appointed as a permanent.
Yes, yes. And the
Uh,
senior most person
principal.
comes in.
And apart from that, seniority will prevail so far as stopgap arrangement is concerned.
Yes.
There is no such requirement to follow the
Entire procedure.
procedure.
Entire procedure. We could have gone for a proper selection itself. There was no
Otherwise,
requirement
this
stopgap.
line, by following the procedure prescribed in the service rules,
That is.
service rules does not prescribe
In charge.
in charge.
Therefore, if we now appoint anybody as in charge, it will be a contempt, my lord. We are in the soup. We are not being able to put in charge.
Lordship
people.
may
That
see
part.
page 64 for a moment, my lord. That is a gradation list of the.
No, that I know. Question is that observation at paragraph 13 is the second part.
They are directed.
So for first part is concerned, okay. For permanent appointment, you follow the rule. But so far as temporary arrangement is concerned, by following the procedure prescribed under the service rules, and that will create the difficulty for both of you.
Entire.
You will not be appointed, he will not be appointed.
Entire state would come in, my lord. All the eligible candidates of the state is, if we follow 13, it will be for the whole state. All candidates, eligible candidates have to come in.
Hmm.
At this point, that is the difficulty with the state, but we have not filed an appeal and therefore difficult for me to also, but I can just bring it to lordship's notice. That difficulty would be there. If someone overlooks and in some district, if someone is appointed, it's an immediate contempt.
But
You
only
can
we are.
file a one cross appeal. Even cross appeal is permitted. Is it not?
It is. We have been asked to prefer review
Yes, I think so.
only for that portion that.
Otherwise, your thing is stalled. Both of you.
Well, we stop.
Seeing the
If we
fact,
read it in letter and spirit, the second part of paragraph
Yes,
30 of the judgment, then
only thing is that.
you'll be retiring both of you.
But if that selection, as required by this honorable court's order, if it is restricted to the school itself, for ad hoc, you keep it within the school itself, even that would
That is different.
give us some leverage to appoint some the senior most person in the school where there is no dispute. But here now, we, if dispute or no dispute, we cannot do it. Therefore, if it is taken up on a short, my lord, on a short notice,
But there has to be something from your side also.
No, I'm
So-
praying of short notice, my lord, or disposal at a short notice, my lord. That is what I was praying for. In the meantime, if you prefer a review or a IA here, that is.
We can make an attempt before holiday, but we don't know.
Now everything is in place in the government also, this process will move now. We require that.
Okay. Something should be on record from your side. Because this will be, go nowhere for the appellant, for the private respondent also. Nobody will be appointed. We can
That
issue
part
short
has not been
notice.
challenged by either of them, so perhaps if the lordships do not interfere with that part, again, things should be at the. problem.
No, that is to be tinkered with, otherwise
Yes, that has-
nobody, neither the appellant nor
But
the,
in the appeal, there is no challenge to that part of the order.
that is
The
nothing.
appeal will fail, even if he wins on the other part, whether he's senior or not, the other part will keep it stalled. Till we bring in a new, we bring in the regular appointee.
Procedure prescribed in the
And that-
rules.
So we'll get a new appointee directly. No question of a stopgap.
Let the post be filled up on regular basis, my lord. No one will be affected.
No, there is no issue about that. That will take time.
That we can do now also. There is no difficulty on that. We can proceed with that thing. But for the time being, when we need to make a stopgap arrangement for whatever
At least
reasons in any other school
till the
also,
regular appointment is
this
made,
part of the order comes in the way.
till the regular appointment is made,
Because
my
it will
lord,
be in rem.
By following the procedure prescribed under the submissions.
School-wise.
procedure বুলি কোৱাৰ লগে লগে rules ৰ গোটেইখিনি আহিব। Rule আহি গ'লে এইবোৰ advertisement ৰ পৰাই আৰম্ভ হ'ব। It will be same exercise like the permanent appointment.
There will be no stopgap arrangement anywhere, even on death or
Or
otherwise
it may
medical
be
invitation, whatever.
school-wise, my lord, seniority, that will also.
So they are also stuck, we'll just issue notice. They are also stuck by death.
Observation.
the petitioner, though his appointment has been set aside, my lord, here he is still working as the principal in charge, as I'm informed.
Yes, status quo.
Status quo will be maintained, my lord.
I, my lord, the lordship will understand that, my lord. I am the senior most teacher, my lord. Then stand of the government is also very clear. Lordship may see the affidavit, my lord, for a moment, my lord. Page 98, my lord. Page 98, para 5. Number 2. On verification of the seniorities, the said HS school, it was found that the writ petitioner Kalyan Das is the senior most teacher of the school as per date of receiving graduate scale of pay, that is 17,998. Then para 4, my lord, page 99. The writ petitioner Kalyan Das, graduate teacher of the said school, acquired master degree in arts in education in Idol in distance mode in the year 2019-21 without obtaining NOC from the appointing authority. He obtained no objection certificate from the then principal of the school, which is not permissible under Rule 13 that is quoted. Then para, in view of the above, the master degree acquired by the writ petitioner is not found as per rule, although he was senior most only on the basis of receiving graduate pay, scale of pay, that is 17,998. His case was not considered for allowing him to act as a principal in charge of the said school. That on the other hand, Shri Naresh Chandra Deka, respondent 5, graduate teacher of the same school, was receiving graduate pay scale with effect of 6/11/98, who acquired MA degree from Guwahati University before joining in service and obtained BA degree on being duly deputed during his service period, was credited and preference was allowed to hold the charge of principal of the school by the imposed order dated 33/2023. So this is the stand of the specific stand of the government. Now he has not challenged even the gradation list, my lord, which is at page 64. Lordship may see gradation list page 64. On name is there Kalyan Das, that is the writ petitioner, and Naren Chandra Das is the appellant. Then date of joining graduate scale, postgraduate scale, column Lordship see Kalyan Das 17/9/98 and Naren Deka 6/11/98. Then date of receiving graduate scale of pay, postgraduate scale of pay, 17/9/6/11, my lord. This is very specific. Neither he's challenged this gradation list, my lord.
Period they count for banana to rule as any.
Is there anything in the rule that ad hoc period is not to be counted?
Normally, my lord, if it is regularized, then it is from the date of joining, my lord.
What is the law?
Nothing in the rules to exclude the ad hoc part. Nothing in the rules to exclude the ad hoc part. Once regularized, it
Yes.
will be for the.
From the
other
date of
purposes. The seniority has to come from the date of actual appointment. Otherwise,
of
regulation would not.
Original appointment.
Otherwise, the regulation would have no meaning. You would have not done anything for the, for the.
On
General
that,
services.
on that point, my lord,
Because
I will
it's
be
not
relying,
technical we are talking
on
about.
that point, my lord, I will be relying on some decisions of the honorable Apex Court, my lord.
Okay, let them, we'll put it on the next week, notice, next Tuesday. Heard, Mr. I.H. Soikia. Learned counsel for the writ appellant. And, oh no, Mr. J. Roy. Or Mr. It's appeal. J. Roy, Learned senior counsel assisted by Mr. Didas. Didas. Learned counsel for the respond number 1. Mr. R. Mojumdar. Learned standing counsel,
Department of School Education.
Department of School Education. For the respondent number 2, 3, and 4, full stop. The in this intra-court appeal, comma, the appellant has essayed a judgment dated 27/2/2024, passed by the learned single judge in a writ petition, comma, WPC number 2066/2023. Full stop. The respondent number 1 hearing as the writ petitioner had preferred the writ petition, comma, WPC number 2066/2023 to assail an order dated 30/03/2023 passed by the Director of Secondary Education, Assam. That is, comma, the respondent number 3 hearing, whereby the writ appellant, thus respondent number 1, was allowed to hold the charge of in-charge principal of B full stop B full stop T dot Higher Secondary School, comma, District Nalbari, under rule, under F full stop R full stop 49 within bracket small c, by way of temporary arrangement, full stop. By the judgment dated 27/2/2024, comma, the learned single judge has set aside and quashed the order dated 33/2023. Full stop. Para. The primary grounds of challenge in the petition were to the effect that the writ petition, that's respondent number 1, was senior to the writ appellant. About both being both assistant teachers,
Isn't it? My lord,
both being assistant teachers in B full stop B full stop T dot Higher Secondary School. Both had both have the postgraduate and B.Ed qualification. Full stop. In the writ petition, comma, the respondents, state respondents had taken a stand that since the postgraduate qualification obtained by the respondent number one, that's writ petitioner, was obtained by the without any permission from the respondent, concerned respondent authority, comma, he was not found eligible. Um, he was not found eligible in the context of Rule 13. The Assam Services within bracket conduct rules 1965. Two. We even act as in charge principal of the school. Full stop. The writ appellant, that's respondent number 5. You have also taken similar step.
My lord,
Had also taken a similar stand. Full stop. However, Commander Learned Single Judge has negated the negated such point, the premise that if a degree had been obtained without prior permission of the appointing authority, the same would be a misconduct under Rule 13 of the Rules 1965. And the same being a misconduct, the relevant proceedings of law there should be a proceeding against such a candidate under the Assam Services within bracket Discipline and Appeal Rules 1964. The Learned Single Judge is of the considered view that without such proceeding, the otherwise valid degree obtained from a university would not invalidate the degree. The matter would require further consideration. Issue notice returnable. No, secondly, the writ appellant has preferred this intra-court appeal inter alia on the ground that Respondent number one repetition. Initial appointment was on ad hoc basis. Full stop. It is also contended that
Rule 24(5), Rule 24(5), my lord. Some secondary education provincial service rules, my lord, 2018.
24(5).
5, page 42, my lord. 5 and 6, if your lordships read, then there is a, in respect of amalgamated schools, my lord, the appointment seniority shall be counted with from substantive appointment or regularization.
Reference has been made to sub-rule 5 of Rule 24 of the Assam Secondary Education within bracket provincialized schools bracket close rules, 2018. And what is your second ground?
Second ground is his appointment. First ground is, my lord, his appointment was ad hoc appointment.
Ad hoc.
Ad hoc
And
appointment.
what is your second ground?
Second ground is Rule 13. Under Rule 13, my lord, if somebody, my lord, pursues a degree, that on the basis of that degree, my lord, he cannot claim promotion to any other higher post. Because in Rule 13, it is
Yes.
specifically
Further
mentioned.
contended that in view of apparent violation of Rule 13 of the Assam Civil Services within bracket conduct rules 1965, comma, the respondent number one writ petitioner is not eligible to hold the post of principal of the school on in-charge basis. The matter would require consideration. Issue notice, the notice is made returnable on next Wednesday. Wednesday, or it will go after vacation.
Wednesday or 27, my lord.
Notice is also issued on the interim prayer, which will, if the
Last week is the motion day, my lord, before
Huh?
holidays.
Wednesday is last day.
No, but
Last
last
week,
week,
Next Tuesday.
Tuesday, some matters has been fixed, my lord. I have some matters fixed, my lord.
Tuesday, it will be Tuesday or Thursday, my lord.
Thursday can be taken up.
No, we'll not go that far.
Tuesday, my lord. Tuesday.
Notice we also issued on interim prayer, extra copies, huh? If it is-
25/6.
if it is not given final consideration, we'll consider your interim prayer. Yes, Mr. Mazumdar.
Oblige me.
পিটিশনৰ ইম্পিং অৰ্ডাৰটো যেতিয়া গভৰ্ণমেণ্টে দিয়ে পাছ কৰে তেতিয়া এইবিলাক কনচিডাৰ কৰিছিল জানাকৈ ৰুলৰ কথা হেৰি কথা এইবিলাক
কোৱা নাই নেকি?
অৰ্ডাৰটো তেনেকুৱা
About the second part of para 30. Take a call. Otherwise, it will stall the opportunity both for the lead appellant and respondent number one.
I'm agreeing, I'm,
We'll get it, that is a different issue, but this observation will stall
I'm agreeing,
everything.
I'm agreeing the school-wise seniority that.
Hmm?
School-wise seniority, my lord, instead of going to entire.
Mr.
board.
Mazumdar has to.
That's it.
Oblige me.
Oh, বৰ দিগদাৰ Integrated for
This is the first time I am handling a teacher's case.
Lordship has rendered the judgment also, my lord, in respect of the seniority of assistant headmaster, my lord.
4 years. Last 4 years, much water have flown under the river from Foragar Bridge. New rules have come.
For hearing item number 2,
There is some writ appeal, right? Sorry, criminal appeal. We have heard for some time. That will, after this, we'll take up. Since 3 and 4, I think for the time being.
Lordship, then five will come. Two other side is absent.
item number 2,
It's not here.
Matter of 2019.
13 years. 13
lord.
years inside the jail. Item number 2. We'll keep it for the time being.
item number 6 and 7.
9. 9 যদি হেৰি মাতক 3 4
Decide to time being.
of time being.
Seven.
Time being.
Lordship, actually, senior was here, just went out. Should I call B. Upadhyay?
Okay. What about Mr. Borua? Rakesh Sharma is available now.
I think he started his matter. I can
Oh.
continue. Can finish my part. It will take some time.
He hasn't started. 3 and 4. And item 5, other side is there, your lordship.
Item 5.
Bhagavati.
কি করবে? নাই দেখুন কাম। ইয়াতে দুইজন না থাকিলে বেয়া হ'ব না এনকে বড়ুৱা আছে ৰাকেশ শৰ্মা নাই ৰাতিপুৱা মেনশ্যন কৰিলে আছে তো বিভাগী আছে এইটো দুটা সেই দুটা
Oh,
লাষ্ট আৰু
oh.
ইআইপি কাষ্টমাৰটো শুনিব সেইটো নাই
5, Bhagavati is there.
ভাগৱতী is there. Who are more in detention?
Oh,
3
it's
and
not-
4 or
Nothing has been mentioned, my lord. Item 4,
Huh?
5.
when the judgment or
19th.
when he was in detention for but how long?
2019 says. Judgment.
2019.
Date of judgment.
Date of judgment.
Date of FIR getting.
And during
17.
trial?
Doing trial also,
Lordship, FIR is of 2017.
2017.
Offense?
OXO.
6.
Or the 5
Okay.
after the vacation.
After the vacation, go to you. After the vacation?
Oh.
Huh? 5.
My lord, I am in respect of
249.
item number 4.
Same.
Same.
Judgment is same.
Judgment is-
Evidence is same.
Evidence is the same. Both are on the spot.
Items 3 and 4.
I don't know, can we come to page 4? Where is the Ejahar?
Ejahar.
Where the story starts. Marked as exhibit 2. 8 June 2014. And The in charge. Noholia Police Outpost, date 10/7/2016.
Hmm.
Subject is in connection with a murder. So our humble submission is that we got the information that my mother, Srimati Bina Chawra, 48 years, wife of late Bisan Chawra, resident of number 2, Naholia village, under the jurisdiction of Naholia Outpost, had passed away while she had been sleeping on bed after dinner. But reaching home in the morning, I saw that my mother's neck was half cut towards left side and there was blood on and around the bed. This is crucial, the language used. Later, I came to know that last night Sri Manglu Sotal, the accused item number 3, son of Sri so-and-so, resident of Naholia, number 2 village, and Sri Taklu Ghatowar, 19 years, son of so-and-so from the same village, had gone to the house where the incident had taken place to sleep there, and that they had killed my innocent mother by cutting her neck with sharp weapon while she had been sleeping. I therefore pray to you to arrest the accused persons, recover the dead body, and send the dead body for postmortem examination. This is my humble prayer before you. So, my lord, this is the signed by Deepak Saura, who is also the son of the victim and the PW6, who is the informant, one of the two sons of the victim, Deepak Saura. So, the scribe has also been examined. Well, now my lord may come to this after, on the basis of this Ejahar on 9 July 2016, this FIR was lost at page 1 itself, under the PS Duliazan. Naholia Outpost, GD entry number 182, date 10 July 2016, time 8:30 PM. The occurrence of the offense is
This
date
182 is exhibited.
page 182.
GD entry exhibited.
No, my lord, that is not exhibited. That is, there is a doubt there. There are two entries. GD entry 182 is not exhibited. 8:30 PM. Occurrence of offense Saturday, date 9/7/2016, time at night. So on 9th of July 2016, it transpires that the offense was stated to have occurred in the house of the victim. From basic reading of these two first.
Come to page 1.
Yes.
Is this GD entry 475?
This is after transfer to the, from the outpost. Another GD entry is.
Okay.
Now, my
Why the
lord,
IO otherwise?
the IO's name is PW8, I believe.
PW8.
That page 1920. He was serving as the in charge of the Naholia Outpost at that time.
So actually information was come to page 19.
My page 19.
See his statement.
This statement. If I may read it.
Yes, yes.
No. On 10 July 2016, I was serving as in charge of Naholia Outpost at about 12:45 PM that
Right.
day.
So first information perhaps.
Person.
A person from
Number 2 Naholia informed over phone that a woman by the name of Bina Saura from that village had been killed. Now he gives a different version. At 12:45 PM daytime on 10/7/2016. Informed over phone, person by name of Bina Saura
Yes.
from village been killed. Accordingly, I made the GD entry number 173 dated 10/7/2016. Now this may be an error, my lord, because there is no 173. There is no mention of 173. I, along with the staff, went to the said village. At the place of occurrence, I found the dead body of Bina Saura lying on the floor of the house. I saw injury on her neck, which had been inflicted with a sharp weapon, and saw blood coming out of the injury. I drew the sketch map, examined the witnesses, and prepared the inquest report. At the place of occurrence, I took accused Taklu Khatwar and Manglus Hotel under my custody. Thereafter, I sent the dead body to AMCH. I came to the outpost along with the accused persons. The same day, the deceased son, Deepak Saura, lodged the written SR, and I forwarded the SR to the Duliajan PS after making ZD entry number 182 at the outpost.
Sorry,
The OC registered Duliajan PS case number 237-16 under section 3 and 234 IPC entrusted me with the charge of investigation. Exhibit 2 is the HR, Exhibit 2 is the signature of the officer in charge, Binay Kumar Burman, which I'm familiar with. I examined the informant. I interrogated the accused persons and arrested them. Exhibit 4 is the sketch map. Exhibit 4.1 is my signature. I collected the post-mortem report, and on finding sufficient materials against Manglu and Taklu, I submitted the charge sheet against them. Exhibit 5 is the charge sheet. Exhibit 5.1 is my signature. On crosswell, I don't know the name of the person who called me over phone. It is not a fact that nobody informed me over phone. Read reason. I did not enclose the extract copy of ZD entry with the documents. I saw injury on the neck only. I did not seize any article. The accused persons did not try to run away. The locals kept the accused persons detained. It is not a fact that I did not investigate case properly and submitted charge sheet on false grounds. My lord, even more FIR, my lord, even on that ground alone, that other testimony of the other witnesses is variance with.
No, variance is one thing.
Yes, my lord.
And hit by section 162 is another thing.
Another thing, my lord.
So whether there was a GD entry,
Yes, yes.
12:45,
12:45.
IO has deposed,
Yes,
then he went to the place of occurrence by making a GD entry 173.
173.
So the knowledge came about at 12:45.
12:45.
FIR later on.
Later.
So whether that FIR is hit by 162 CRBC.
My lord, I'll examine.
Okay, I will come back.
Okay.
Learning amicus curiae, Mr. N. Hassan is unwell lordship. Unwell lordship. Suffering from fever lordship. Lordship may kindly fix the matter after 1 minute.
Okay.
Item number 2.
Item number 2, lordship.
Sir,
N. Hassan.
your name?
A. Hassan.
A. Hassan, learned counsel. Appearing for Mr. N. Hassan, learned amicus curiae has submitted, and Mr. N. Hassan is indisposed. Ms. B. Bhuyan, learned senior counsel and additional public prosecutor for the response state is present. In view of the prayer meet on behalf of Mr. N. Hassan, learned amicus curiae, the matter is passed over for the day.
Deputy.
Yes.
No, my lord. From basic gist of the materials of the case, we see that there has been an information transmitted to the police officer concerned over the phone at 12:45 PM regarding commission of a cognizable offense. So, my lord, subject to your lordship's correction, my understanding of the law, really particular section, is that when there is an information disclosed other than by way of an informant giving an Ezahar, because this is post the fact of that information and knowledge coming to the police officer. So when such information came at 12:45, the procedure that ought to have been adopted was to transmit a report thereof to the concerned magistrate, and thereafter through the superior officer to the superintendent of police, and thereafter proceed to the spot personally or by deputing a authorized police officer in that regard, section 157. That is the next step, logical step. To ensure, the reason for that is apparently the reason for that is that the magistrate concerned may keep monitoring the progress of that investigation if no other facts come to light. Now, in this case, because the other conspectus of facts revealed that there was indeed an incident that happened. So I would like to take my loss to PW1 to show how this actually GD entry 173 stands in contrast to GD entry 182, the information received in both the cases. Normally, my lord, PW one, page 9. This is the son. From the facts, I believe this is the younger son of the victim, Bina Chawla. Page 9. If I may read well.
Yes.
I know both the accused persons. My name is Sam Chawla. I know both the accused persons. The deceased Bina Chawla was my mother who died on 10/7/2016. On the night of occurrence. So the IO states he received information on.
The incident happened in the night intervening 9/7 and 10/7 perhaps.
Perhaps, possibly. That is the question. So there may be a typographical error somewhere.
Whatever.
That died on 10 July. On the night of occurrence, I, along with my mother and Ajit Bhakta, was sleeping in the interior room of our residence, while the accused persons Taklu and Manglu were sleeping in the outer room of our residence after having party. The accused persons who were sleeping outside came from the outer room towards my mother's room and held my mother and slit her neck with a dao. Both the accused persons threatened us not to disclose about the incident lest they would kill us. The next morning, the accused persons went away. This is important, my lord. There is a contradiction. We were lying inside our house as we were terrified. The next morning, I went to my elder brother Deepak Chawla's house, who resides separately, and informed him about the incident. This is PW6, who resides separately, and informed him about the incident in the morning after the accused persons had gone away, because till that time he was terrified, under threat by both of them. My brother Deepak came to our house and found my mother dead, and he went out in search of the accused persons. Again, my lord, went out in search, they had gone away. Thereafter, my brother informed the police and lodged the Ezhar. My mother sustained cut injury on her neck. The police came and examined the body of my mother and took the body for post-mortem examination. The police also arrested the accused persons. The police recorded my statement during investigation. Taklu has been Taklu has been staying in our house for about 2 months. I do not know if Ajit invited Manglu to stay in our house on the night of the incident. The alleged incident took place at about 2 a.m. midnight. Ajit is my cousin brother and he has been staying with us for about 3-4 years. It is not a fact that Ajit killed my mother. It is not a fact that I have given false evidence against the accused persons as tutored by Ajit. There are other households near my house. My brother caught the accused persons and handed them to the police personnel. Again, this is, so in this case, the PW1, the gist of it is that while he and his cousin were in the house, they were sleeping in his mother, the victim, and his cousin was sleeping in the interior room along with him. The accused 2 persons were in the outer room. They came in the middle of the night, 2 a.m. at midnight, slit the mother's neck with a dao and threatened them not to leave the house or else they would kill them. Then they went away in the morning. He went and informed his brother who resides separately, the PW6, and thereafter PW6 went to the police, lodged the Ezhar, and police came. And this is the rest is the cross-examination of that. They've been staying for about 2 months. Accused 1 has been staying for 2 months. Accused 2 came on the night of the incident. So there are Ajit Bhakta is also one crucial link of the puzzle here, who is the cousin of PW1. Now, my lord,
So PW1 appears to be an eyewitness.
PW1 and what has to be the cousin also has to be an eyewitness because they were in the interior room with the mother. When at the time when they came in, accused came in and slit her neck with the dao.
So whether the party was going on till 2 a.m. midnight.
But that party is not that part is not taken. They were sleeping. The word mentioned here is they were sleeping in the outer room after the party, possibly.
The thing is that whether the accused persons have committed the offense in presence of the other 2 persons.
That is what will be clear after the reading both the PW1 and PW2 together. I will read that, then taking them both together because they are in the same room at the same time. Page 11, PW2 is Ajit Bhakta. I know both the accused persons. The deceased Meena, it should be Bina, was my Borma who died in the month of July. On the date of incident, I, along with Sam Chowra and his mother, was sleeping in our residence and the accused persons were sleeping in the outer room. In the middle of the night, both the accused persons came to our room and caught my Burma. And when we woke up, the accused Manglu slit the neck of my Burma with a dao. So after they woke up, they saw slitting the neck with the dao. My aunt Burma died as the accused threatened us not to disclose the incident to anybody lest they would kill us. Again, the same as PW1. We were terrified and we were also lying in the room and the accused persons were in the house for the whole night. In the morning, Sam Chowra went to the house of his brother Deepak, who used to reside near his house, and informed the matter. Deepak came in the morning and saw the body of my Burma, and thereafter he informed the matter to police. Police came and took the body with them, also apprehended the accused persons. Police recorded my statement. The police apprehended the accused persons and took the body with them. On cross, the accused Taklu, Adrit Siba, was staying in the house of Sam Chowra for about 2 months at the time of the alleged incident, same as PW1. It is not a fact that I called Manglu to stay in the house of Sam Chowra on the date of the alleged incident. The alleged incident took place about 1 a.m. midnight. After the incident, we all four were in the same room and Burma's body was lying in the same room. Both the accused persons were in the house till the arrival of the police. There is one contradiction here. PW1 says he left in the morning, then he got the courage to go there. They were in the house till the arrival of the police, PW2 says. They did not try to flee. I do not know why the accused persons had killed my Burma. I do not know if the dao was seized by police used by the accused persons. The police recorded my statement in the police station. It is not a fact that I had killed my Burma and have falsely inculpated the accused persons with the killing of my Burma and have given false evidence. So, my lord, that materially there is a parity in what PW1 and PW2 have stated, except that PW2 goes on to say that only after the accused came into the room and they woke up, then the throat was slit. So they have to be treated as eyewitnesses if his statement is to be taken. And
regarding sleeping in the outer room,
yes,
both are consistent.
Consistent.
Sleeping in with the disease,
yes,
by this PW1 and PW2,
yes,
that was also consistent.
Yes.
Slitting the neck by dao, that is also consistent.
Yes.
And all were inside the room or house, that is also consistent.
Consistent.
In PW2 chief,
yes,
what he did not say is that
in fact, category
next morning,
yes,
what he did not say, threatened part was also consistent.
Consistent.
What he did not say is
they went away in the morning, the accused person. And he also mentions the person who actually did the act of slitting the throat, that is the accused number 2, Manglu.
34 is there.
34 is there. 34 is there. That is what both did.
And what he has said, somewhat not consistent with PW1, is that both the persons were in the house till the arrival of the police.
No, the PW1 says they went away in the morning.
Went away in the morning.
And my brother, after I informed my brother went after them and apprehended the accused. That is in the cross he has mentioned. My brother caught the accused persons and handed them to police personnel, that is PW6.
Otherwise, both of them have claimed that they witnessed the incident.
They have witnessed it. Then that is what 334. 34. PW3 is not direct no. It is hearsay. I know both he is a Sukru Chowra. I know both the accused persons and the informant Deepak Chowra, who are from our villages. The deceased victim Bina Chowra was the mother of Deepak Chowra. About a year ago, on the next day of the occurrence, the younger son of Bina Chowra, namely Som Chowra, informed me that his mother was lying inside their house. So that is again the information given on here says that murder was lying inside the house. I went there and also many people gathered there. The accused persons were also present at the place of occurrence. I saw the victim's dead body. The complainant lost the case against the accused persons. On the previous night of the incident, the accused persons had food in the victim's house and they stayed overnight in the victim's house. The police recorded my statement. On cross, I do not know if the accused persons were present in Brina Chaura's house in the night. I heard in the morning that they were there. Som told me that the accused persons were in the house of the victim in the previous night. As I did not witness the incident, I stated before police I did not witness the incident. My lord, there is a slight thread emerging here that accused persons were present in the morning at the place of occurrence when this person came there. And this person was intimated by whom? By PW1, the Sam Chaura, who was also the eyewitness. Now, my lord, there is one disturbing fact here that the consistent explanation of both PW1 and PW2 is that they were threatened and they were in mortal fear of their lives. Therefore, they did not wander out of the house from night till morning. Only possible explanation why PW1 got out of the house to inform his brother would be if the accused had gone away. The threat, immediate threat is removed. Now I can go to the police or the neighbors and inform them. But if I accept the testimony of PW2, it means, and PW3, it means that the accused did not go away at all. So that fear of mortal harm and peril which was there at night would also have been there in their presence if they were remaining all throughout. There is a slight inconsistency here so far as the reasoning goes. Now PW4, my lord. This is also another person named Bina Chaura, not the victim. Page 14. I know both the accused persons and the complainant Deepak Chaura and the victim Bina Chaura. They are all from my village. Bina Chaura died last year in the month of July. On the next day of the occurrence, I saw the accused Taklu in the deceased house. And thereafter, the son of the deceased, Som Chaura, came and informed me that his mother was lying unconscious inside the house. Another information given to a victim that mother was lying inside the house, not that the mother was dead, killed, murdered, was lying inside the house. The words used are significant. I tried to wake up the victim and nudged her, thereby implying that it is true. She was not told that it has been murdered or dead. She thinks that PW4 thinks that the person lying on the floor is still alive. I tried to wake up the victim and nudged her and found that her feet were closed and the victim would not wake up. Then I brought one lamp, Saki, as it was dark, and I noticed blood on the bed. And in the meantime, the villagers arrived and thereafter I informed the villagers about the incident. Thereafter, police came and recorded my statement. I heard from the deceased victim's son, Som and Ajit, that the accused person killed the deceased. Police conducted inquest of a dead body. Exhibit 1 is inquest report. Exhibit 1 is my signature. On cross, the deceased victim was a healthy person before her death. At the time of her death, her son and her nephew, Ajit, was staying with her. Her nephew has been staying with her for a long time. I do not know if the accused persons were present in the house of the victim, but I saw them on the following day. I did not see injury on the body of the victim, but I noticed blood stain. Again, I don't know injury seen, but that is there present. Did not notice. The police came and took away with them Monglu, Som and Ajit. I do not know how the incident took place. So while PW 3 and 4 both have run on a common theme that even though they are told the information by PW1, they are not told about the factum of death or murder. They find it out from themselves on their own, and thereafter the police comes. So, and they do not know if that accused Taklu and Manglu were staying in the house of the deceased for a long time. That is one crucial point which has come up here. That yes, PW2 Ajit has been staying for a long time, but there is no mention here, as stated by PW1 and PW2, that the accused were actually also staying in the house for some time.
One of the accused was staying.
But that is PW1 and PW2 saying, but not corroborated by PW3 and 4.
They're outsider.
Outsiders. But near neighbors, man, neighbors. These are neighbors only. This is a village, they are neighbors.
But when questions were put, whether they have said so.
But that question was never put. PW5.
Defense also suggestion also, or what's defense suggestion is that they try to rope in Ojit also.
Yes, that is to that extent, yes.
The defense suggestion was that Ojit might also be involved.
That is, that was the pattern they were going. PW5 is another neighbor, Sanja Chawla. I know the accused persons. The complainant and the deceased victim, Bina Chawla, all are my neighbors. On the next morning of the occurrence, the son of the deceased, Som Chawla, came to me and told me that his mother was lying with bloodstain in the house. Again, no mention of the word death or murder. He tried to wake her up, but she did not respond, which is startling. If this is an eyewitness, then he would know. There was no use in waking her up. Then I immediately went to the house of the victim and I noticed blood stain on the deceased and the bed. The police came and took away the accused persons with them to the police station. Police recorded my statement. I did not witness any injury on the body of the deceased victim. I do not know if the accused person stayed in the deceased person's house on the night of the incident. I do not know how the deceased victim died. Now, note, the position of PW6, this is the informant, this is the second son. Second son would be, his name was Deepak Chawla, yes, page 16. Or not, I know both the accused persons. The deceased Bina Chawla is my mother. About 1 year back, my mother died. On the night of the incident, I was in my younger brother's house. He is referring to Sam Chawla. His younger brother, PW1, was in their house, mother, along with the mother. He was in his younger brother's house, separately, residing separately. On the next night, my brother informed me that my mother's body was cold and she has died. This is again night of the incident, and on the next night, he says. Now, I rushed to my house and found my mother's body on the bed. My brother informed me that on the date of incident, accused Manglu and Taklu were present at that night. Then I went to the Noholi outpost to lodge an Ezhar written by person named Horen. Exhibit 2 is the FIR, Exhibit 2 is my signature thereon. I noticed injury on my mother's neck. Police recorded my statement. Cross-examination. I do not know what is written in the Ezhar. I do not know how my mother died. I do not know when the incident occurred. My brother informed me about the incident. I have no personal knowledge about the incident occurred in my house on that night. So the FIR is basically tutor. But my lord, that again, the common thread running in through is that PW1, whenever he informs someone, even his own brother, he does not say that his mother has been murdered, killed by so-and-so. He says, she is lying, my brother's body was cold and she has died, which is a very odd way of putting things. Page 17.
Age is also to be taken into account. PW1's age is also to be noticed.
Yes.
Yes, he was about, say, 15 years.
Yes, sir. 15 years. 16 years.
No, at the time of testimony, 16,
Yeah.
but at the time of offense, it was 15 years.
That aspect of age.
What is death? What is murder? What is that? These are to be comprehended
Yes, sir.
by a person aged about 15 years and person aged about 30 years are different.
Look, in this case, the learned trial court also took that into account.
They have also admitted that somebody killed,
Somebody killed.
and the nature of injury will lead only to death.
Yes.
That is also not in doubt. The nature of injury received by the disease is of such a nature that it will lead to death.
Yes, madam, but on the nature of injury, I want to point out one thing, that page 17 is that the one who conducted the post-mortem examination demonstrator
Yes.
mentions on the, in paragraph 3, injuries, naturing. Chop wound of size 15 to 5 present over left side of neck up to vertebral body, deep underlying muscles, vessels, clean cut. Margins of the wound contuses, blood clot or adherence to wound margins. My lord, this is the action of, is called a slit. It is a slit action, slit the throat. Whereas a dao, which is more prominently known as a chop weapon, it is not the weapon of choice for slitting a throat. Again, I have no experience of these matters, but I would expect the villager would know which weapon to use while slitting a throat. A knife, a small knife, sharp knife is more aptly used for slitting a person's throat. Dao is more when we cut things with a chopping motion.
15 centimeter is this much.
15 centimeters this much.
Plus 5 centimeter is this much.
Yes,
That is not a knife.
that is what we got.
That cannot be knife.
So
5 centimeter is this much. 15 centimeter is this much.
therefore, my lord, when I say that
15
PW,
into 5.
yes, yes. Then when PW1 says slit my throat, slit my
Body
mother's
deep.
throat.
Left side of the neck up to vertebral body deep.
Deep, yes, very
It
deep.
cannot be knife.
It cannot be a knife. But my point is that the PW1 says when they slit the throat, it would have been more appropriate to say literally the neck would have been severed with a 5 centimeter edge. There is no mention of blood on the clothes. With such a wound, there is no mention of blood on the clothes of the accused who were holding her. One of the accused was holding her.
Those comes in the category of defective investigation.
My lord, that is right. No blood on the clothes. And my lord, interesting fact, if I accept that they were there all throughout the night, then there was no time for the accused to dispose of the murder weapon. The police sees no murder weapon or doubt. All of them were in the room. There was no scope for the murder weapon to be disposed of till the police arrived. But still no murder weapon was found.
Injuries on the neck left side.
All other than that,
Because
all denial. And
So
that
far,
is
what had happened inside the room or inside the house during the night intervening 9/7 and 10/7. PW1 and PW2, they have disclosed. Whether that has a ring of truth or not, that is one thing. But after the morning, that is confusing. Till the information received by IO at 12:45. How, why these two, whether they had gone out as deposed by PW1 or they were somewhere in the compound, and how PW1 managed to go out, only this is the doubt. Other things, so far, slitting, it is consistent with the medical evidence.
medical evidence.
Night time, one says 1 p.m., the other says 2 p.m. That is not
an issue.
material.
Metro.
Only question is that morning and 12:45 and the conduct of the accused. What is the conduct? That is the only thing which are bothering. Otherwise, two eyewitness. So far, what had happened inside the house,
Only
they were consistent.
Hmm.
And their testimony is consistent with medical. Assault is consistent. And whether they were there or not, 313, we have said, we are there.
Yeah.
But only thing that somebody might have killed. Monglu or Takluk, somebody says. And the next part, morning till 12:45, when the IO received the phone. After morning till 12:45, the conduct, which is not very consistent, but what had transpired inside the house, that is quite clear.
My lord, so far as the deposition of the PW8 is concerned, that is the IO, we have already read on page 19. My lord, let me read it again in light of the facts discussed. On 10 July 2016, I was serving as in charge of Nahalia outpost. At about 12:45 PM, person from number 2 Nahalia informed over phone that a woman by name of Bina Chawra from the village had been killed. So my lord, as the question fell from your lordship, that section 162, that bar thereof, my lord, this is, I believe, in the nature of a cryptic message, which would not amount to an FIR. Therefore, the next subsequent information would have to be treated as the FIR. So this would be all statements made during preliminary investigation. But even discounting that, the FIR, no substantial difference would be made, because all things would again revert back to the statements of the PW1 and PW2, because PW1 informed PW6, basically.
PW1.
PW1, the Sam Chawra. He informed PW6, the Deepak Chawra, who on that basis of that information lodged the Ejahat. At the place of occurrence, I found the dead body of Bina Chawra lying on the floor of the house. I saw injury on her neck, which had been inflicted with a sharp weapon, and
So
saw
he prepared the sketch map,
Yes.
inquest report, and took the two accused persons into custody and forwarded the dead body for postmortem.
for postmortem as well.
And thereafter returned Ejahat.
Thereafter is did the Ejahat at 8:30 PM in the night. It is now, my lord, then this came to outpost, we forwarded the Ejahat in the cross-examination. So there is no name of the person who called over the phone, but he denies that nobody informed him over the phones. That suggestion was put to him. I did not enclose the extract copy of GD entry with the documents. I saw injury on the neck only. I did not seize any article. The accused persons did not try to run away. The locals kept the accused persons detained. It is not a fact that I did not investigate the case properly. Now, my lord, on the question of conduct, I would like to take my lordships to the judgment and order of the learned trial court, where this fact was discussed in detail. My lord, may come to page 36. Defense also raised the plea of the conduct, and this was discussed by the learned trial court. Page 36 of the judgment, para 15. After careful scrutiny of the evidence of PWs 1 and 2, it can be safely held that Bina Chawra was killed in the intervening night of 9 July 16 and 10 July 16. It can also be safely held that both PW 1 and 2 are eyewitnesses. The argument of the learned defense counsel about the conduct of the accused persons under section
Yes.
Under Section 8 of the Indian Evidence Act 1872, after the incident is relevant. She has submitted that the accused persons were innocent, and so they remained back inside the house even after the incident. On the contrary, I would like to emphasize that the accused persons were speculating criminal liability, and so they stayed back in the house till the morning hours in order to prevent the other two inmates of the house from informing the police about the incident. Rather, Section 8 of the Evidence Act affirms that the conduct of the accused leads us to believe that they were apprehending arrest or a criminal case against them, the accused person stayed back to exercise pressure by threats and intimidation to the other two inmates of the house who appears to be timid. Sri Sukru Chawra testified as PW3 that the accused persons and the informant are from his village. Bina Chawra was the mother of Deepak Chawra. The incident occurred about a year ago. On the following day of the incident, Bina's younger son, Sam Chawra, informed him that his mother was lying inside the house. He went there and found accused persons were also present at the place of occurrence. He noticed the victim's body. The complainant lost this case against the accused persons. On the previous night, the accused persons had food in the victim's house and stayed overnight in their house. The presence of corpus delicti cannot be denied. Sukru Chawra saw the body in the house of the victim, and many people were already assembled there. The accused persons were also present. It is pertinent to mention at this juncture that the learned defense counsel laid stress in her argument that the conduct of the accused persons is again relevant in the evidence of this witness. The evidence of this witness depicts that the accused persons were present even after the people assembled in Bina Chawra's house. Had they been guilty of the alleged offense, they would have fled from the place of occurrence to avoid arrest. it has already been held in my foregoing discussions that while the accused persons remain back even after the alleged incident, their threats has to be taken into consideration. PW3 directly did not implicate the accused persons. At the same time, his evidence fortifies the evidence of the other witnesses. It is clear that the accused person flexed their muscles and exercised threats with such aggression that Sam Chora and Ajit Bhakta stayed indoors till the morning as they were terrified. Now, my lord, this I submit is an assumption. There is no manner of saying who was aggressor in this matter. There is no evidence laid on that count. At page at 99, I call it. Similarly, Bina Chora is Sukru Chora's wife, and she testified as PW4 that both the accused persons, the complaint depiction victim Bina Chora, are from their village. Bina Chora died in the previous year of the month of July. On the day of the incident, she saw the accused Taklu in Bina Chora's house, and thereafter, Bina Chora's son, Sam Chora, came and informed her that the mother is lying unconscious inside the house. She tried to wake up the victim and nudged her and found that her feet were contracted and the victim did not respond. Then she brought one lamp, Saki, as it was dark, and she noticed blood in the bed. And in the meantime, the villagers arrived, and thereafter she informed the villagers about the incident. Police came and recorded a statement. She heard from victims Sam and Ajit that the accused persons killed the deceased. Police held inquest in her presence. So and so is the inquest report, and so is the signature. In her cross-examination, she testified that at the time of death, the victim's son and her nephew Ajit were staying with her. Her nephew was staying with her for a long time. She did not know if the accused persons were present at the victim's house, but she saw them on the following day. She did not notice blood on the victim's body, but she noticed blood stain. It is pertinent to mention at this stage that evidence of this witness remained consistent to her statement under section 161 CRPC. Evidence of the witnesses PW3 and 4 remain uncontradicted and uncontroverted. So, my lord, uncontradicted, uncontroverted. So, you know, this
Basically, it is PW1, PW2,
yes,
and medical evidence, 313, and plus post-occurrence conduct or behavior of the accused, and the inconsistency between PW1 and PW2 regarding the presence of the two accused persons. Those are post-occurrence, morning. But PW1 sneaked out of the house to inform his elder brother. That is when in presence of the accused inside the campus, maybe inside the campus or maybe inside the house. That is what, but core of the prosecution story, what happened inside the house, that is not somewhat disturbed.
Yes, my lord. Because, my lord, I would say that if this PW...
Why they have behaved like that or conducted like that post-occurrence, morning. That is the only...
My lord, that is why I'm saying that if this evidence is said to remain uncontroverted, that means the learned trial court has accepted implicitly the fact that those persons accused were in the house till the arrival of the police. And that is a material contradiction.
So why they have allowed the PW1 to go out of the house? That is not explained also by the accused.
Not explained by the accused as well. But no question has been put to them. That question it is the duty of the trial court to put a particular question where deemed fit, which has not been put or involved.
That will affect the prosecution story.
In this case, again, there is about the conduct. Why I'm stressing on the conduct? Because the conduct aspect affected the sentencing part to life imprisonment. Because the learned trial court presumed that these are aggressive persons who have flexed their muscles and forced these people, these two young boys, PW1 and PW2, not to disclose to the police.
No, sentencing part will come when it can be converted from 302 to culpable homicide of first degree or second degree or third degree. 304 part 1 or 304 part 2.
Yes.
I don't think this is the case which can be converted.
No, not
so life is life.
Life is life.
Only alternative is death. Since the trial court has given life, it will remain life or it will be set aside. That's all.
Yes. And again,
that's all. There cannot be any conversion.
And at page 40
so
also.
Sentencing part,
yes.
Even after discussion, if it is 302,
Hmm.
Discussion will be limited to life or death.
Well, yes, my lord, and again, interesting part in page, last line of page 40, if my lord comes, I'll just read that last line. Page 40, last line, it
Yes.
starts from Sam Chora is a young lad and he is terrified of the accused person's threats, and thus he could not go out of the house because both the accused persons were present with him. As soon as he got the scope, he immediately rushed to his brother's house and informed him about the incident. And that is also again not true. The Sam Chora is informed again PW3, then he went and informed PW4. A multitude of witnesses that his mother was actually lying on the floor of the house. Thereafter, he goes to his brother Deepak Chora's house. And then, my lord, if it comes to page PW 3 and 4 testimony as well. PW 3 testimony, fourth line again, deposition, page 13. About a year ago, on the next day of the occurrence, younger son of Bina Chora, namely Som Chora, informed me that his mother was lying inside their house. I went there and many people also gathered there. So, not only the brother, basically entire neighbors were informed by Som Chora. And during the presence of the accused, while they were sitting outside the house as well. In PW4 also, he says the same thing, that son of the deceased Som Chora came and informed me that his mother was lying unconscious inside the house. Thereafter, the villagers arrived. The threat perception was still material there because the villagers were not on the scene. There was no public on the scene. Som Chora was wandering around, informing whoever he saw that his mother was lying unconscious. And as soon as he, in the learned trial court also observed, as soon as he got the scope, he immediately rushed to his brother's house and informed him about the incident. Sam Chora is only 16 years of age and Ajit Bhakta is only 20 years of age at present. Whereas the accused persons are older than both Ajit and Sam and aggressive by nature. The reluctance of Deepak Chora and his wife Sandhya Chora to directly implicate the accused persons does not exonerate the accused persons. The uncontroverted evidence of the eyewitnesses proves beyond reasonable doubt accused persons acted in furtherance of the common intention and killed the victim Bina Chora. Now again, my lord, again the aspect comes of the motive. What possible motive or gain would those two accused have to dispose of their victim?
But in the case of direct evidence, motive is not required.
My lord, because two persons only here on one side and two persons on the other side. Two persons sleeping outside in the outer room who have said the common thing that they did not know what was happening in the inner room.
Have you seen 161 statements?
161 statements, my lord, this is not there. This is not there. No. Okay. Only 313 is there.
161.
I do not think we have this in the paper book. I have the three.
Not, it is not in the paper book.
Yes.
We have seen paper, 161 statements.
My lord, then I leave it.
So from here, we have seen that motive is not relevant in a case of direct evidence. Motive could be seen from there, from the 161 statement, which were recorded immediately.
And my lord, the final point is regarding the post-mortem report, which was taken in page.
You can read 161. What was the motive? We are not going into that.
My lord, my lord. I understand.
Motive were there.
Motive was there, maybe. My lord, only the question remaining was that the post-mortem report, which took place on 11th of July 2016 at roughly 12:45 p.m. gives the period of death as 18 to 36 hours approximately. Working backwards, my submission is that that places the incident of the commission of offense at the extreme end, upper limit of the post-mortem. Therefore, I'm praying for certain benefit, that the benefit of doubt should be at least extended to the accused. That because I'm working back 36 hours, that would be under one, as has been stated, at 1 PM or 2 PM on 9th and 10th night, intervening night. That is at page 58.
12:45.
12:45, 11
You-
daytime,
Relate back to 36 hours.
36 hours,
Will be
12:45
12:45 PM night.
on the
Night.
night of date of.
PW1 says 2 o'clock, PW2 says 1
On
o'clock.
1 o'clock.
Not inconsistent.
Not inconsistent, but even though it is the extremity end of that range.
These are approximation.
And that factum of the toes being contracted of the victim, as stated by PW4, indicates that rigor mortis had already set in at that time,
After 8 hours,
after 8 hours.
consistent then. Rigor mortis set in after 8 hours perhaps starts. And what is there in the rigor mortis present? PM report.
PM report, the rigor mortis is present, that took place of the body. That was at the long time. It may stay up till 48 hours as well.
Only thing is morning to 12:45 PM, GD entry. Other things are not this PW1 and not PW2. Both are not shaken,
Not a shaking.
not shaken.
Suggestion is not.
Night. Person night and for this.
To be added. You are for Piglu or Tiklu?
I'm for Taklu.
Huh?
Taklu.
Taklu.
I'm from Monglo.
Monglu.
Your lordship has gone through the entire
Taklu.
record. However, your lordship, I'll do your
Monglu.
Your lordship has prima facie observed what I have seen, that the evidence regarding the accused slitting the neck of the victim has remained uncontroverted. However, I'd like to see that from the angle of the post-conduct behavior, because the case of the prosecution is that the accused came inside the room, they were outside, they came inside the room, then they killed the victim. They remained in the room till morning. They threatened them. And all the four were there inside the room. Then, however, curiously enough, Sam was allowed to go. They didn't try to flee. It has come in the cross of PW2. The PW2 and PW1 contradicts each other. This is also vital. They remain inside the room. They don't, and they remain till the police come. So now, they don't try to, even after Sam goes away, they don't try to flee. Whereas the entire night they were threatening them, it seems. And they don't kill the witness also, nor do they flee. Now, we have to see the entire evidence whether this behavior of the accused is opposed to or confirm human behavior, normal human behavior. If that be so, then the statement given by the PW1 and PW2 regarding them witnessing that incident also becomes doubtful. Because it does not fall into places. It does not reflect normal human behavior. The consequence of event, the series of events has to reflect normal human behavior.
No,
Especially when,
How the accused will behave or the witnesses will behave.
yes,
It will depend upon.
yes, but still
circumstances.
there is certain human standard that has to be seen, or normal human in kind of such situation. I will just place one Supreme Court judgment to the effect. The principle I'm relying on
Maybe
here
it maybe seem unnecessary.
is
Seems to
unnecessary,
be unnecessary.
especially,
But, human behavior cannot be predicted.
yes, you cannot be predicted, but they didn't try to dispose of the murder weapon. All four were inside the room as per PW2. They didn't, because all things has to be seen now. If PW1 and PW statements are not taken into record, then who was inside the room? These are interested witnesses. Interested not only because they're related, interested because otherwise they become prime
When a
suspect,
person becomes
prime suspect,
interested,
interested.
what is the principle for to become an interested witness?
Interest,
They are related witness.
yes, related.
Now, what is an interested witness? An interested, one can become related and interested witness. But when a witness is become interested,
They are interested in the prosecution of the victim
why?
because otherwise they become prime suspect. Because they are inside the room, they are outside the room. This is first thing that is, it is a admitted fact by Willard one. If that goes, they become prime suspect. So they are interested in the prosecution of the victim. And if that is kept in mind and the human behavior is kept in mind, it does not fall into place.
So what is the foundation laid for PW1 to become interested witness?
Because they, both of them are inside the room,
Inside the room is one thing.
but the force
What
increase.
is the foundation laid by defense that PW1 is interested witness?
It is from the record, from their own witness and from own evidence, because they are outside, their entry is not being proved. Force entry.
There was no force entry, Mr. Sharma.
But then,
There was no force entry at
Yes.
all. It is not the case of the defense at all. It is
The-
not a case of the defense at all that there is a force entry.
I am trying to say that the prosecution evidence itself falls. I'll just try to see why, because they have not tried to dispose of even a murder weapon. A murder weapon was not seized. Because, Your Lordship, I'm just trying to impress upon Your Lordship to the fact that they didn't flee, they didn't kill the second witness when they had the opportunity. They did not try to dispose of the body. They were sitting there till the police came. And only thing, PWD1 and PWD2 are the eyewitness. Now the quality of the evidence has to be taken into account because rest of the stories, they are all contradicting themselves. PWD1 says, yeah, I'll just read. The next morning, the accused person went away. But across, they were in the house till the arrival of police. They did not try to flee. PWD2 says.
Only inconsistency, Mr. Sharma, as with Borua, we have gone through the evidence. Only inconsistency is that PW1 says they went away.
Okay.
What he meant by went away, we don't know. So far, PW2 is concerned, they said they were present. Even after
They were present in the house till the arrival of police. Not
yes,
even.
they were present even after the morning.
Yes.
So far PW1 is concerned, he says that they went away. So thereafter he got the opportunity to go out.
Yes.
This is the only inconsistency we have found, which we are trying to find out. And their presence or absence. This prosecution is not in a position to go into the minds of the accused. That is not possible. So far as the motive, conduct, motive, we can understand. That is not in the record. But only inconsistency, we have found that why they remain present. Remain present. That's all.
That shows they are not guilty mind.
That does not show that's guilty. It may
I'll just one place and also.
create a doubt.
That's what I have to do, Your Lordship. I have to just create a doubt. And even the medical witness, PWD 7, I think. PWD 7. In his cross, he says this can be caused by accident. More so, keeping in mind the murder weapon was not at all seized. Whereas they remain inside the house, the police, so there was no chance of disposing of the murder weapon, if at all. So if that be so, keeping in mind the evidence of PWD 7 in his cross, that it can be caused by accident.
No, from the cross-examination of PW1 and PW2, can it be said that it was an accidental case?
Now, only thing, Your
Is it
Lordship.
your case that an accident took place and she sustained
Yes.
injury?
Now, in that regard, Your Lordship, what I want to submit is that PWD 1 and 2 are contradicting. Their deposition is neither wholly unreliable.
Legal point, they are not.
Not in the
Not on
core,
this.
don't say-
Yes.
such a core case of the prosecution remain intact. Post occurrence conduct. PW1 and PW2, they deposed about post occurrence conduct. There is some inconsistency.
In that regard, what I want to submit is that, Your Lordship, the PW 1 and 2 is not wholly unreliable, nor wholly reliable. It is a case where the with evidence are partly reliable or not wholly unreliable, not wholly reliable.
Medical evidence corroborated there.
But the clause says it can be by accident also.
No, but
And keeping in mind the murder weapon was not
at
seized, Your
no
Lordship.
point of time you have suggested PW1 and 2 that their mother sustained injury by accident, by way of accident.
It can be by accident also, he says in his clause.
No, maybe in the
Yes.
oh,
The PW 7,
no.
he says in his clause.
Did you put such question to PW1 and 2 in cross-examination?
Now, no, Your Lordship, what I want to now see, keeping on entire evidence on record, whether it is wholly reliable or wholly unreliable. It is neither. It is neither wholly unreliable nor wholly reliable. In that case, Your Lordship, apart from this evidence, has to look into the other evidence, other corroborative evidence, other circumstances of the case. It cannot be then solely basis of the statement of PW 1 and 2. Because it's not the quantity is the quality that Your Lordship has to examine, because here there's some part are unreliable and it does not conform to the basic human conduct or nature a person would react in case he commits this kind of crime. So in that view of the matter, more so when it is partly unreliable.
So this is the judgment you have relied upon?
Yes, Your Lordship. First, regarding the senseless conduct, first, 2003 11 SCC 19. Paragraph 6 and 7, paragraph 6, last line just I want to read. All these witnesses are very closely related to the disease. 7 I want to read, mostly read, right? If this part of the evidence of the prosecution is to be excluded, then in our opinion that there is no sufficient material to hold the appellant guilty. Be that as it may, we may refer to the recovery part relied upon by the courts below. We notice that one of the witnesses to the recovery has not supported the prosecution case. Here there is no recovery at all, Your Lordship. That apart, the incident in question had taken place on 6/4/1986 and the accused arrested only on 11/4, nearly 4 days thereafter. We find it extremely difficult to believe that a person who is involved in such a serious crime like murder would still be wearing clothes which are bloodstained even 4 days after the murder, which fact we find is opposed to normal human conduct. In this background, the evidence of the hostile witness that so and so. Next is, since our opinion, the prosecution case in the regard to the dying declaration, also the recovery is beyond reasonable doubt, hence a benefit. So what the senseless conduct or whether it is opposed to human conduct has to be looked into when the evidence of PW 1 and 2 is not wholly unreliable, not wholly reliable.
Is a case of no eyewitness.
Yes, I'm on the principle of senseless conduct. And I will come to the evidence of later also.
This
If
is
there,
circumstantial.
yes,
This is circumstantial.
yes,
No eyewitness.
right.
And there is prior enmity.
Right. Here, there is no
There is
enemy.
prior enmity.
Here, there is no motive, no murder weapon seized. Other circumstantial evidence will not support because medical weapons say, because all throughout, if a lordship sees PW 1, PW 2, PW 3, 4, everyone says lying in unconscious state. They didn't say he was killed. Anyway, your lordship, there's one more judgment. To 1993. Your lordship, here, paragraph 3, I want to rely. However, lordship, though there is a single eyewitness here, basically I want to say that PW 1 and 2 are part and related. It's like, though they are not single eyewitness, this case primarily hinges on the testimony of a single eyewitness, so and so thing. Indeed, conviction can be based on the testimony of a single eyewitness, and there is no rule of law or evidence which says to the contrary, provided the sole witnesses passes the test of reliability. So long as a single eyewitness is wholly reliable, witness, the courts have no difficulty in basing conviction on his testimony alone. However, where the single eyewitness not found to be wholly reliable witness, in that sense, there are some circumstances which may show that he could have interest in the prosecution. I am submitting that the PW 1 and 2 has interest, because otherwise they would become the prime suspect under section 106. Then the courts generally insist upon some independent corroboration of his testimony in the materials, particularly before recording conviction. In my humble submission, only corroborating thing is the medical evidence, but in his cross, the witness says it can be by accident, Your Lordship. And also to be kept in mind, all throughout, Sam, when he goes, even in the FIR, it says lying unconscious. Later they came to know that someone killed. And there's one more judgment, Your Lordship, last. Right.
Yes.
So my submission on the basis of the case law is that if it is not wholly unreliable, then other corroborative evidence has to be looked into, Your Lordship, especially when these two PW 1 and 2 are interested witness. This, Your Lordship, the facts are a bit important, but no, I'll not trouble Your Lordship. Here the sole witness specifically categorically states rather in his testimony that he saw the accused giving blows and killing the victim therein. In spite of such statement, how the Supreme Court has dealt, if your Lordship can turn to para 10. May I read or? Para 10. The law of evidence does not require any particular number of witnesses to be examined in proof of a given fact. However, faced with the testimony of a single witness, the court may classify the oral witness into three categories, namely wholly reliable, wholly unreliable, and neither wholly reliable nor wholly unreliable. In the first two categories, there may be no difficulty in accepting or discarding the testimony of the single witnesses. The difficulty arises in the third category of cases. The court has to be circumspect and has to look for corroboration in materials particulars by reliable witness, direct or circumstantial, before acting upon the testimony of a single witness. In the case at hand, we can neither place implicit reliance on or totally discard the testimony of PW 9, as it can neither be called wholly reliable nor wholly unreliable. Manu is a witness who could have been naturally present with his brother while plowing the field. However, we find this testimony to have been substantially improved at the trial than one it is to begin with when the first information report of the incident was lost. Here, Lordship, PW 5 and the FIR, they're contradictory. Because in the FIR, he says, I came to know initially my mother was lying unconscious. Later, I came to know. Wherever PW 1 in his statement says, I inform about the incident to the PW 5.
To bring contradiction with the FIR, there is certain procedure.
Yes.
Which is not followed. So that submission will not be accepted.
It was not put to the, I understand. But anyway.
FIR is not a substantive piece of evidence. If this PW 6 had made any improvement, then it should have been brought to his notice. PW 6 informant.
He has said, I did not know what is written in the Isaiah.
Reported.
He did not say what.
Reported.
Yes.
It has been reported. He's not a witness to the actual incident.
Right. But if I may, if your lordship sees para 12 also, if I can go down, and there is another very material aspect of the incident, and you cannot resist observing the investigation in the case has been very defective. The investigating officer did not prepare any site plan of the place of occurrence. If your lordship sees the site plan here, it reveals nothing. It's just a basic drawing. Samples of blast and earth were not sent for chemical observation, even here. No effort seems to have been made to recover or seize any weapon of offense, even here. No witness of the locality who could have been present near the place of occurrence at the time of incident has been interrogated. Here, PW3 and PW4 seems to be the neighbor, but they hear no human cry. It was
That's midnight.
midnight,
One
allegedly.
question of, there should be resistance
Sorry, lordship.
for hue and cry. There should be resistance. Middle of the night, one shopping moon. Apparently with a sharp edged whip.
Lordship, I'll not trouble because your lordship has gone through the entire record. What my submission is this, your lordship. When these two witnesses were interested witness, their second part of the evidence are wholly unreliable. They contradict each other. And their evidence also does not reflect normal human behavior of a guilty person. In that view of the matter, in convicting the accused solely on the basis of part of their evidence, without any corroboration of other witnesses or other evidence or other document circumstances of the case, will that be justified here? That's my sum and substance of my entire argument.
Main to main.
It was like very value ever. Depend কৰিছে।
Video value এটা part is like
অ',
not the part actually, কিন্তু part হ'ব লাগিব। Somebody তাতে কি কৰিছে video value. Be relaxed.
And in paragraph 13 here, it says it therefore clear that genesis or the root cause of the incident is not known. Because one thing your lordship has to bear in mind, when they are threatening PW1 and 2 not to leave and they're keeping them confined, how Sam was allowed to go? And if he has somehow escaped, it is natural that they will also escape. They will not remain there. Your lordship.
But they were under intoxication as per evidence of PW1.
That one thing. It is not come out, your lordship. It's not there, your lordship.
No, someone has stated that they were
No,
celebrating
in-
party.
it's not there, your lordship. Not from the evidence. And there is an explanation in 313. Both of us were outside. So the prosecution had to prove the entry.
Who stated they were outside? Which one?
They were in the outside room. It's from the prosecution. It came inside. Prosecution case is that they came inside. However, 313 statement, they say we were always outside.
No, this accused number 1, he categorically stated that he was inside the room.
No, he was inside the outer room.
Yes.
Your lordship. Your lordship says at page 23. I was residing in some house for 2 years. Disease was my Burma. That night, Burma asked us to stay in a house and we stayed over at Burma's house. We are sleeping in the outer room. And Ajit, Som and Burma were sleeping inside the room. Their entry is only on the basis of PW1 and PW2. So that's why I'm saying they are interested to prove their entry. So that's why PW1 Ajit and so my interested witness. Apart from being related, they're interested that the accused are prosecuted.
This is clearly in the realm of suggestion only. Ojit, putting the suggestion, remain in the realm of suggestion only. To prove something that Ojit was an interested witness, you should have put in something more. There are absolutely nothing. To put the suggestion to PW1 and PW2 or any other, it remain in the realm of suggestion. Nothing more, nothing less. You have to put in something more, even in the 313, that yes, Ojit, something more, plausible. It remains in the realm of suggestion. You can put any number of suggestions everywhere, but you have not cast any aspersion on PW1. You cast aspersion on PW2 by putting suggestion. But you did not cast any aspersion on PW1 that he was not present with the mother. How can you categorize him in the category of interested person? He could be a related person, Ojit, you may say, but so far you did not make any whisper about PW1. Absolutely nothing. So he cannot be to make a person interested with this. Maybe he is related, but related and interested is another thing.
Yes, I understand.
Related is one thing, related and interested is another thing. Now putting PW1, he is a 15-year-old boy of the mother. To put him in the category of interested and related witness, it is too far-fetched in the absence of anything, not even a suggestion. To put him in a bracket of wholly unreliable, no, partly reliable, partly unreliable, then we can test his testimony with other evidence.
Yes,
Vedivelu says you can look for corroboration.
yes, that's
Only thing what is slight inconsistency is that morning to 12:45, that is what we are thinking. Now we cannot go into the minds of either the accused. So for some inconsistency in case of ocular evidence, well, all right. But prosecution cannot read the minds of the accused.
but with due respect, Your Lordship, PW1 and 2, the inconsistency is major because they says the accused fled away. It was caught by Deepak, his brother, and handed over to police.
Not fled away, went away.
Went away, yes, Your Lordship.
Fled away is one thing, went away is one thing.
But he was caught by his brother Deepak and handed over.
Went away, we don't know, went away from the room or went away from the campus.
No,
That
but
is
the
also not-
PW2, Your Lordship, in
it
his
is not clear.
no,
Went
in his
away.
accused, he says they were in the house till arrival of police. So they were in the room itself. And one thing to be looked into, Your Lordship, the murder weapon, that means if we take PW2 evidence in totality, there was no chance of disposing of, then why it was not seized or examined? And there was no effort made to dispose of the murder weapon. That has to be looked into, Your Lordship.
To dispose of the murder weapon.
Because it was inside the room, they were in the room, they didn't flee as per PW2. So
That
it
is
was,
what only morning thing.
so this conduct of the human behavior has to be seen ultimately.
Human behavior in the face of,
They didn't attempt to flee, Your Lordship.
okay. Yes.
Mr. Sharma, this PW1,
Yes. Yes.
in the fifth line.
Yes, sir. Right.
Of our residence after having party.
In the outside, yes, outer room of our residence. Having party, not alcohol hours.
After
Party
having
may be feast also. I just plead your lordship just to keep examine the aspect that they were outside, they were inside. And rest of the prosecution case contradicts PW1 and PW2. So whether on that basis of that just statement, whether they can be convicted. Or your lordship will examine the other corroborative evidence, which I say that PWD7 in his cross said it can be caused by accident also. And no murder weapon has been seized, no motive has been reflected in the evidence.
No, if we believe the evidence of PW1 and PW2, there is no question of motive.
Yes, but thing is here it's partly reliable, partly unreliable. Then your lordship, I urge upon your lordship, your lordship has to see the other corroborative evidence or the circumstance of the case. Circumstance of the case will also include their behavior, conduct, non-seizure of any murder weapon when there was no opportunity to dispose of
That
the.
may be failing to seize the recover and seize the murder weapon. That may be defect in the investigation of this case. But can we discard the prosecution case on account of
Not
failing
solely
to
on this, not
seize and,
solely. Yeah, yes, I agree,
recover
not
and
solely
seize
on
the
this. However, the
weapon?
entirety, when the evidence is partly reliable, partly unreliable, then all these factors, motive, non-seizure, conduct, not trying to flee, not trying to dispose of, also letting Sam go when they were holding them through the entire night, but they're letting him curiously to go in the morning. Entire thing. Whether
That part only inconsistency is that behavioral aspect of the accused persons after the morning. After the morning, letting PW1 to go, that is one part. Whether they were inside the campus or not, that is one thing which is not clear. But so far as slitting the neck of the deceased, that was clear.
And
PW 313, they were present.
They were present outside a lot. They gave an explanation a lot. That explanation is how far.
That can come after the evaluation of the prosecution.
Yes.
witness.
In the light of this, if I may say, there's another aspect.
If the prosecution story is believable, then that would add weight to the prosecution story. 313.
Because otherwise, in all fairness, if that statement was not there, even their presence in the night was doubtful because none of the other witnesses says they were present in the night.
Go back on your 313.
Right.
Now, presence, you have not said, let us see the cross-examination of PW1 and PW2.
Yes.
Did you say that we are not present there?
No, that is not there. So if
That is not the
313 is
case
there,
of the
then
defense.
that I agree. So that's why I'm
The
stating.
case of the defense is they were very much present.
Yes. What I'm trying to impress upon your lordship is they were outside in the outer room.
No, you see the sketch map.
Yes.
All the rooms are connected.
Connected, we have seen.
Yes, that I have seen in a
Yes.
vertical
Mm.
row. So if I may, again, in the cost of repetition, if I summarize my argument, if it is partly unreliable, then your lordship may have to look into other corroborative evidence and circumstances of the case, which include the behavior of the accused person, non-discovery of the weapon, more so when there was no opportunity to dispose of the murder weapon because they were remained inside the room and no motive. More and though, if I may again say, they are interested witness. And one thing, just your lordship, for one thing I want to point out.
You have not brought anything to put them in the interested witness. I am repeatedly saying.
Yes,
I am repeatedly saying.
This, I'm just summarizing this, if lordship may, this. And one thing I want to, if your lordship, the PWD 8 evidence, the timing. Here, as per the PWD 8, he got the information at 12:45, your lordship. He makes a GD entry of 173 at the outpost. Then he conducts the investigation. Then he transfers the case to the police station and makes a GD entry 182 at the next page, your lordship. This is his statement, your lordship. Now, so GD entry 182 obviously has to be after some duration of time from 12:45, your lordship. Yes, so 182. If your lordship come to the FIR, serial number 3, page 1, general GD entry 182, date so and so, time 8:30. And information received again surprisingly 9:45.
This one is
12:45.
10/7, 9:45, GD entry 475.
Whereas this GD entry 182 has to be after some duration of point from 12:45.
That is, he said, after making GD entry, written Azhar, I forwarded the Azhar to the Duliajan after making GD entry 182. Come to page 5.
Yes.
Received and entered right now Holia OP GD entry number 182 on 10/7. And this 9:45 PM is after in-30. That was by officer in charge.
Okay. It's just, this has got nothing to do with
So
this will not.
till the receipt of written Azhar, it was not investigation in the proper sense. Investigation commenced after receipt of the Azhar.
Okay, the preliminary inquiry.
What is preliminary?
Oh,
Let me
yeah, right.
step. First thing is that when somebody was told to be killed, so his first and foremost duty is to reach the place of occurrence. And inquest is for the purpose of ascertaining the cause of death. So this is telling.
Yes.
12:45, GD entry 173, GD entry 182 at 8:30 by the officer in charge, Naholi outpost.
Yes.
Then he forwarded the FIR to the officer in charge. Then he received and made the GD entry 9:45 on 10/7 and case has been registered. Yes, prosecution.
Yes. Exactly. Much obliged.
Lordship, my humble submission is that the prosecution case is basically on the two eyewitnesses, that is PW1 and PW2, Lordship, which is found to be very much. Lordship.
Mike. Or bit louder.
Lordship, the prosecution case is based on the eyewitnesses, that is PW1 and PW2. And they are found to be very much consistent, corroborative, and truthful on a material point that at that relevant point of time, the accused were present along with the deceased and the two inmates, that is PW1 and 2, Lordship. And that remains unchallenged and unrebutted, Lordship. And on the material point that the accused person duos slit the neck of the deceased with a dowel, and they have revealed the fact that threatened was received from the accused person not to divulge the fact to anyone, or they would kill them, Lordship. So therefore, as my learned friends has raised a question, because they didn't divulge the fact that they had not killed, that the killing part is something missing when they disclosed the fact to the other prosecution witnesses, only because of that reason, because they have threatened by the accused persons not to divulge the fact in front of the accused person. And because PW1 and 2 they are very tender age because one is near about 15 and one is near about 19 at the time of incident, Lordship. And thereafter, Lordship, it is also corroborative and supported by the medical evidence that slot has been done with a chalk owned. That is very much supportive, corroborated. And Lordship, other attending circumstances also lead to the fact that the accused person has killed the deceased, and it can be the circumstances can be a basis of conviction if it is well proved and found to be conclusive in nature. So those attending circumstances are, Lordship. At that relevant point of time, both the accused persons were present and they will remain all along with the other inmates at the place of occurrence. And this conduct of the accused persons has revealed the fact that just to prevent the two inmates from informing about the occurrence to the other person. And thereafter, Lordship, there is a controversy regarding, as my learned friend have raised an issue.
Yes.
There is minor discrepancy regarding this, Lordship. So PW1 says he went away, the accused persons went away after the incident, and PW says the accused persons were present. So these discrepancies, so this is also, we can make some submission to that regard, Lordship, because PW1 says that after the occurrence, both the persons fled away in the morning. PW says deposed that thereafter, Lordship, he went to his brother. This is very natural on his part to inform that his mother is died, killed by the accused persons. He straight away went to the place of informant, that is PW6. And after informing him, the PW6 came to the spot and saw his mother's body is lying on the bed. And PW6 deposed it. PW1 informed that on the date of occurrence, both the accused were present. And thereafter, Lordship, while PW1 is cross-examined, that is at page 10, there is a statement, Lordship, my brother caught the accused persons and handed them to the police personnel. After receiving the information from PW1, PW6 went to the spot.
Okay, there is no sound.
Right?
Yes, there is no.
Thereafter,
You will not have to single witness. I have seen the original one.
Yes, yes. That's in the
Single soul eyewitness, soul. And suppose there is some inconsistency. So for PW1 is concerned, he was a natural witness. Natural witness. His presence is not doubted.
no doubt.
no.
Yes.
So, Lordship, PW1 stated in his examination in SIP that supposing for a moment they went away after the incident in the morning. And in his cross, he has stated that thereafter he has informed his brother. PW6 came to the spot, and in his cross, that is at page 10, my brother caught the accused person. After they went away, PW6 went to caught them, and he has apprehended the accused persons and brought back them to the place of occurrence. Thereafter, Lordship, PW3, the villager, from whose deposition it becomes clear that he has he has saw the accused persons at the place of occurrence. So there's a sequence of circumstances. Once they went away, then he has been caught by the PW6, that the brother of the PW1. Then he has brought back the accused person to the place of occurrence. And the village, after the incident, after his brother's arrival, other villagers come to the place of occurrence and they have saw the presence of the accused persons, and thereafter they have handed over the accused persons to the police personnel. And testimony of PW 1 and 2, they have unequivocally stated. Testimony of PW 1 and 2, who happens to be the eyewitnesses, they have unequivocally stated that at that relevant point of time, PW 1 and 2 were sleeping all along with the deceased person in a separate room, and the other accused persons were living in a separate room. And in the midnight, both the accused person came to their room and held the deceased and slit her on neck with a dowel, and both accused persons witnessed the incident. That is very much remained unshaken while they were cross-examining by the defense. The fact remains that the accused person slit the deceased on her neck. And this is also supported by the evidence of medical evidence. So this is my humble submission. It's this all the relevant attending with circumstances lead to give a cogent and it forms a cogent and complete chain of circumstances, which is found to be well proved and conclusive in nature, and that can be the basis of conviction. This is my humble submission.
Mr. Borua, when is your DNA case?
Tomorrow.
Tomorrow.
I had a slight request to make of your lordship. Could it be taken up early? Because
We'll try. It is in the hearing list.
it's in a hearing list. No,
We'll find out. If the expert comes,
yes, expert.
then we'll take up early.
Expert is
Right?
Yes, he's coming.
Otherwise, no purpose.
No, expert
Right?
is coming. Yes, sir.
If the expert comes, expert will be coming. Then we'll take up early. Then we'll decide what to do thereafter. Okay. And there is one more case, right? 5-6 or 6-7. Those two will be taken up some other day because public prosecutor has to make submission, right? You were supposed to make submission in that case. We'll put it on another day. We can complete this. Okay, otherwise we'll put this tomorrow or day after tomorrow. But we'll start. We'll not keep it pending. Mr. Dev was available. He is available. Rujit Dev. He made some request for early hearing.
Yes. Perhaps it's not available.
Item number 3 and 4. 3 and 4. Both are from J.
Bhutanji.
Mr. Deka, we may take your case on some other day. Since we have concluded this hearing, we'll start this. Within this week only. Within this week, right? On Thursday? We'll find out. Both this criminal appeals from jail are preferred against a judgment an order dated 30/5/2019 passed by the legislation in Dibrugarh in sessions case number 147/2016 by the judgment and order dated 30/5/2019, both the accused appellant who faced the trial, and be convicted for the offense of murder under section 302, Indian Penal Code in need of section 34, IPC. Full stop. Both the accused appellants have been sentenced to undergo imprisonment for life and to pay a fine of rupees 1,000 each, in default of payment of fine, to undergo rigorous imprisonment for another 1 month. Full stop. It has been observed that it has been directed to pay compensation to the victim's son of the deceased under the Assam Victim Compensation Scheme, 2012. Full stop. Para. The investigation was initiated. The case is, the instant case is regarding the death of one Bina Chawda. Full stop. The investigation of the case was initiated on the basis of a first information report lodged by the son of the deceased, Deepak Chawda, within bracket PW6 as the informant before the officer in charge, Naoholia Police Outpost, on 10/7/2016. Full stop. In the FIR, the informant had inter alia alleged that his mother, Bina Chawda, was a resident of number 2, Naoholia village. And she passed away while sleeping on bed after having dinner in the night intervening 9/7/2016 and 10/7/2016. Full stop. When informed, the informant went to the house of his mother and found the neck of his mother half cut towards left side. And there was blood on and around the bed. Full stop. The informant had named the two accused appellant's hearing in the affair and stated that they had gone to the house where the incident had taken place, to sleep. And it was them who had killed the mother of the informant by cutting her neck with a sharp weapon while she was sleeping. Full stop. On receipt of the affair, the in charge now Holia police outpost received the same vide Naholia Outpost General Diary Entry number 182 dated 10/7/2016 and forwarded the original affair to the officer in charge Duliajan Police Station for registering a case under proper sections of law. Full stop. At the same time, the in charge Naholia Police Station Outpost took up the investigation of the case. Full stop. On receipt of the FIR, the officer in charge, Duliajan Police Station, registered the same as Duliajan Police Station case number 237/2016 for the offenses under section 302 IPC, read with section 34 IPC. Full stop. And took note of the fact that the in charge Naholia Outpost, Uttam Odhikari, PW 8, sub-inspector had already taken up the investigation. Full stop. Para. From the materials on record, it has emerged that it was about 12:45 PM on 10/7/2016, the IO of the case, that is PW 8, received an information of a phone that the woman named Bina Chawra had been killed. Full stop. On receipt of the said information of her phone, PW 8 registered the information, provide General Diary Entry number 176 dated 10/7/2016. Full stop. After making the entry, he, along with staff, proceeded to the place of occurrence, that is, the house of PO, house of place of late Bina Chawra, number 2, Naholia village. Full stop. At the PO, the IO PW 8 found the dead body of Bina Chawra lying on the floor of the house. Full stop. The IO drew a sketch map of the PO and also recorded the statements of witnesses and the statements of witnesses. Full stop. The IO PW also conducted inquest on the dead body of the deceased and prepared an inquest report within bracket EXT1. Full stop. Finding the presence of the two accused persons and the PO, the IO PW8 took them into custody. Full stop. After sending the dead body for the disease to the Assam Medical College and Hospital for postmortem examination, the IOPW8 took both the accused persons to the Naholia outpost. Full stop. Thereafter, the son of the deceased Deepak Chara, as the informant, lodged a written report before at Naholi outpost. Pusta. The in charge Naholi outpost, that is PW8, received the said written FIR White General Dairy entry number 182, dated 10/7/2016 at the outpost, and forwarded the same FIR for registration. After the postmortem examination of the dead body of the deceased was performed at the Assam Medical College and Hospital AMCH on 11/7/2000. After the postmortem examination was performed at so-and-so by Dr. Torojyoti Gogoi. 7. Demonstrator, the Department of Forensic Medicine, AMCH. Full stop. After completing investigation into the case, Duliajan Police Station case number 237/2016 within bracket corresponding GR case number 1828/2016, the IO PW8 submitted HRC under section 173 to CRPC. White SARCID number 119/2016 on 30/7/2016, finding a prima facie case established against the two accused persons for the offense of murder under section 302 IPC, read with section 34 IPC. Poster. On submission of the charge sheet, the Court of Learned Judicial Magistrate First Class Dibrugarh secured the production appearance of the two accused persons from judicial custody on 22/11/2016. Full stop. After furnishing the copies under section 307, CRPC to the two accused persons, the learned Judicial Magistrate First Class Dibrugarh committed the case records of GR case number 1828/2016 to the Court of Sessions Dibrugarh, finding The offense under section 302 IPC exclusively tribal by the Court of Sessions by an order commitment dated 22/11/2016. On receipt of the case records of GR case number 1828/2016, the Court of Sessions, Dibrugarh, registered the same as Sessions case number 147/2016. Para. After appearance of the two accused persons before it, the learned session judge, Dibrugarh, within the trial court for short. After hearing the learned public prosecutor and the learned defense counsel, and after perusal of the materials on record, framed the following charge against the two accused persons on 30/11/2016, page 7. When the charge was read over, explained and read over and explained to the two accused persons, they claimed not guilty. And they pleaded not guilty and they claimed innocence and claimed to be tried. So during the course of the trial, the prosecution side examined 8 number of witnesses and exhibited 5 number of documents in order to bring the charge against the two accused persons. After closure of the prosecution witness evidence, the accused persons were examined under section 313 CRPC by putting before them the incriminating materials free from the evidence laid by the prosecution. Full stop. There, the claim of the accused person, the plea of the accused person was denied. Full stop. Thereafter, the learned trial court, after hearing the learned counsel for the parties and after evaluation of the appreciation of the evidence to materials on record, delivered the judgment dated so and so, whereby the accused persons returning the finding of guilt against the two accused persons for the offense of murder under section 302 IPC, read with section 34 IPC. Full stop. After hearing the learned counsel for the after hearing the accused persons on the point of sentence under section 235 within bracket 2 CRPC, the accused persons have been sentenced in a manner indicated above. Full stop. We have heard Mr. R. Sharma, learned amicus curiae for the appellant, Monglu Chotal, in criminal appeal J number 100/2019, and Mr. N.K. Borwal, learned amicus curiae for the accused appellant, Taklu Ghatuar, in criminal appeal J 101/2019. Full stop. We have also heard MS S.H. Boral, learned additional public prosecutor for the respondent state. Full stop. The meticulously, no, have elaborately have referred to the testimonies of the prosecution witnesses, more particularly, the testimonies of PW1 and PW2, comma, whom the prosecution have, no, who, according to the prosecution, comma, were the eyewitness to the incident of assault on the deceased. Full stop. Pointing to the testimonies of PW1 and PW2, comma, the learned amicus curiae have submitted that if the testimony of PW1 and PW2 are read in juxtaposition, comma, a number of inconsistencies can be noticed, especially with regard to post occurrence conduct or post or regarding their testimonies about the events after the alleged occurrence. Full stop. It has been contended that while according to PW1, comma, the two accused persons went away from the house of the deceased at one point of time, but comma, according to PW2, comma, both the accused persons remained in the house till arrival of police. Full stop. From the conduct of the accused persons, that they had never made efforts to run away from the alleged place of occurrence, comma, the such conduct is suggestive of their innocence, as the said fact is also as proposed of the learned amicus curiae have submitted that the IO PW8 had also deposed to the effect that the accused persons did not try to run away from the house where the alleged occurrence took place. Full stop. The learned amicus curiae have also contended that the prosecution witnesses, comma, PW1 and PW2 cannot be placed to be cannot be placed in the category of wholly reliable witnesses. Full stop. Referring to the testimonies of other prosecution witnesses, there's PW 2, 3, PW4, PW5, and PW6. Comma. It is submitted that they had they also found the body of the disease, that they had also found the person, they had also found Bina Chawra lying inside the house, but their testimony was somewhat different from the testimonies of PW1 and PW2. It has been contended that the alleged weapon of assault was never recovered. And the same has a vital bearing. Full stop. Yes, what do about medical evidence? What do you say? Any medical evidence? On medical evidence, you have said something?
Yes, Manu, regarding the chop wound, which could not have been made with the action of slitting the throat.
Okay. It has also been contended that the injury found on the body of the disease was a chop wound. Whereas, and the same, and such kind of wound is not consistent with the testimonies of PW1 and PW2, who deposed that the neck of the disease was slit by a dowel. Full stop. In support of submissions, the learned amicus, plural, have referred to the decisions in Khalil Khan, Lalu Manji, Anil Phukan. These three?
Yes.
Anil Phukan,
Yes.
Khalil Khan, Lalu Manji.
So the quality, not the quantity. Quality, not the quantity.
It is submitted, it has been submitted that for a serious crime like murder, it is the quality of evidence, not the quantity, which requires evaluation and on a strict scrutiny test, the prosecution case, according to them, have fallen short of the standard to prove the case beyond the reasonable doubts. Full stop. Para. Au contraire, learned additional public prosecutor has supported the judgment and order of conviction and sentence passed by the learned trial court. Full stop. It is a submission of the learned additional public prosecutor, MS Bora, learned additional public prosecutor, that there were no apparent inconsistency in the testimonies of the two eyewitnesses, PW1 and PW2. On any material points. Full stop. The consistencies, pointed out by the learned amicus so and so, are of trivial, are not on material points. And the same, and those consistencies have not affected the core of the prosecution case. Full stop. It has been contended that the ocular evidence in the form of testimonies of PW1 and PW2 are found to be consistent with the medical evidence in the form of PME report exhibit 2 and the testimony of the autopsy doctor from PW7. Full stop. As the prosecution has been able to bring the case against the accused appellant, establish the case beyond all reasonable doubt, the interim judgment of the learned trial court does not require any interference. Full stop. We have duly considered the submissions of the learned counsel for the parties and have also gone through the materials stroke evidence on record, including the testimonies of the prosecution witnesses and other evidence available in the case record subsections case number so and so in original. So we have also gone through the citations referred to by the learned counsel for the parties. We'll post it day after tomorrow. Yes, Mr. Das, about your case, what to do? We have single benches also. If to the date, because
It will take some time because
to the date we can proceed. Because I generally don't upgrade. And I am not deviated from it.
If it can be next
can-
Tuesday, 25th,
We can try.
next,
We can try.
next Tuesday. no?
13.
So the date of 25th we can try.
30. Put it on 13. DK what is it? DK Das.
Estate by my junior just gone out. PK Darji.
It's the best
See-
DK already. Yes, so
20.
Mr. Day. And Mr. DK. Put it on 13.
25th. Item number 13, 25th.
Last second. If it reaches, we'll take up.
Madam.
Yes, Mr. Sharma, we'll take this up day after tomorrow.
Alright.
Hard.
Lordship, I had a small prayer. Item number 11, maybe list on next week.
Now that's not possible.
Lordship,
We'll lift it over. Not possible.
on next,
We have cases lined up.
the accused is more than 5 years in jail.
Ask Mr. Sharma, how much? Your is 8 years.
Yeah, item 11.
We are not fixing it. Item 11 should proceed some. Yes, sorry, please. 3 years only. Item 11.
Than 5 years. 5 years, 7 months. 24/11/2017, he was arrested. Till then, he is on bail. Item 11.
Item 11, 3 years, 6 months only.
Oh, I think it's wrongly written.
3 years, 6 months.
It's wrongly.
There are 8 years. Mr. Day is 7 years.
No, 10 years plus.
10 years. So we'll put it ahead of you.
May it please your lordship. Lordship, here the petitioner is assured of the payment and his great pay by the honorable district judge. So we are instructed to withdraw this case with a liberty to file afresh if
Okay. Yes,
required.
anything?
My lord, the relief has been granted, my lord.
Okay.
This is the order passed by the Chief Judicial Magistrate. my lord. She is
Have you
drawing.
received this? Have you received this copy?
I don't think.
I'll finish have a copy. my lord.
No.
Okay, let liberty remains.
My lord,
Your name, please.
Endeka.
Okay. Heard MS and Dekal, Learned Counsel for the petition, and Mr. G. Boishwal, Learned Standing Counsel GHC for the respondent number 3, 4, and 5. Full stop. MS Dekal, Learned Counsel for the petitioner has submitted, on instruction, that the petitioner wants to withdraw the writ petition, with the liberty to approach again. Full stop. Mr. Boishwal, Learned Standing Counsel, GHC, has placed a communication bearing number so and so, dated 11/6/2024 of the Chief Judicial Magistrate, Nagaon, and has submitted that steps are being taken for fixation of the petitioner's grade pay at rupees 10,300 WEF 22/01/2020. That is, from the date of her joining as head assistant after receipt of a notification bearing number so and so dated 35/2024 from the state government. Full stop. It is, Mr. Boishwal has thus submitted that the petitioner would be granted appropriate relief. Full stop. In view of the submissions made by the Learned Counsel for the parties, the writ petition is closed on withdrawal, reserving the liberty to the petitioner to approach again. Let liberty process
my
is on.
lord,